Good morning, everyone. The time is 10 o'clock and this inquiry is resumed. Can everyone see and hear me okay, first of all? Yeah, I can see Mr. Tucker, Mr. Morgan and Mr. Griggs Trevarden. Once other people, Mr. Neil and a few other faces, Mr. Hewitts and so on. I'm aware that this event is being accessed via the Teams town hall format, so that people will be people watching this event who can't participate, but they can view what's being said. I believe it's being streamed with a slight delay, perhaps to those watching as attendees only. But obviously, anyone who's come via the same link as me will be able to speak if necessary and appear on screen as well. Are we any issues with IT that we need to mention before we get going? Anything from the council?
Nothing that I'm aware of, sir. Thank you.
Okay, thank you. Well, just let me know if there are any issues as we go along. And I believe a recording of this meeting should be made available online afterwards. So thank you to the council for facilitating this. For the benefit of everyone who's in this meeting this morning, this is the final day of the inquiry that relates to the decision of Bath and North East Somerset Council to refuse planning permission for up to 290 dwellings and associated development, including the provision of a spine road at parcel 4234 at Coombe Hay Lane in Bath. Just a few housekeeping matters. If people can ensure mobile phones and other devices not in use for this event are switched to silent, please. Microphones should be muted and cameras switched off unless you're speaking or one of the barristers. In terms of the Teams format, we do have a raised hand function. So if you do need to raise your hand, like I've just done there, you can do that via the toolbar. There is probably a chat function, but I'd rather not use that as it's not easy to monitor that. So if we can avoid using that, please. And I think otherwise it's the usual sort of protocol in terms of Teams. Obviously, introduce anybody new who's coming on camera for the first time, and so on. Mr. Tucker, are you testing your hand, or is that a genuine?
No, it's a genuine hand, sir. So the one thing that did flash up just before you came onto the call was to say that there was a transcript that was being taken of this. I've certainly no objection to a transcript being taken, but it's the first time I've encountered this in relation to a virtual inquiry where a transcript's been taken. I don't know whether, as an abundance of caution, it might be sensible for the council to add that transcript to the inquiry documents at the end. I'm not suggesting it has any particular utility. It's just that if there's a transcript, it ought to be in the public domain.
Okay, thank you, Mr. Tucker. Any comments, Mr. Morgan?
I wasn't aware of that, and I think I agree with my learned friend, in short, and that will hopefully that can be done and will be done if it can be.
Okay, Mr. Neil. Thank you, Mr. Morgan. Mr. Neil, any comments on that?
No, sir. No objection to that. So proposed course of action.
Thank you. Well, yes, I assume it might just be a setting of this particular Teams meeting, but yes, if that can be made available afterwards as an inquiry document, that would be helpful. Thank you. Anything else on sort of IT related points? Just to say then, in terms of the timings today, we'll aim to have sessions of around 60 minutes each. I think we're going to be starting with a roundtable discussion on conditions and obligations, which may take around an hour or thereabouts. Then we'll have a short break, and then we'll begin to hear closing submissions from each party, and probably take short breaks between each closing submission, or even a longer lunch break, depending on where we've got to in the proceedings. So yes, that's the plan for today, is to do the conditions and obligations and closing submissions, hear any cost applications, and then close the inquiry. Before we move on to the roundtable discussion on conditions and obligations, just to run through some document updates, and there's been quite a few over the weekend, so I'll just make sure that everyone is happy with that. They all are on the SharePoint website, so hopefully people have seen them. But the combined technical notes, which was the note from the appellant about the Burnt House Road or Burnt House Lane access, was added as ID 30. Then we have an update to the 106 that we'll be looking at today, which is ID 31. That's a Word document. Then I have a note from the appellant on title interests as ID 32, which we can come to if we need to during the 106 discussions. Then I have something called a title bundle as ID 33, which sets out the various title information for the proposed signatories to the 106. I then got an ID 34, which is a document on resetting the local plan. This was the document that's flagged up on the penultimate day of the inquiry. I've had comments from the council on this. I don't think they've been added yet, but they've certainly been circulated, and comments from the appellant, which have been added as ID 38. I don't know whether the Rule 6 party were intending to comment or not, Mr. Neil.
So no, we don't have any comment. We've seen what the council said and we endorse what they've said in their note.
Okay, thank you. That's helpful. Anything more? Does anyone intend to say anything more about that, Mr. Morgan?
So I'm just going to say that I've just had an email to confirm that our email note is now ID 40.
Okay.
I believe. And I wasn't going to say anything more. I've seen the appellants, and I think we've dealt with those matters in our note as well. So I wasn't going to say anything more now or in my closing. Thank you.
Okay, thank you. Mr. Tucker, anything more to say from the appellant?
I do intend to reference it in closing, sir, but I've got nothing to say at this stage. Thank you.
Okay, thank you. Then moving on through the list of additional documents, the Rule 6 party's response to the Burnt House Road technical note is being added as ID 35. Thank you to the Rule 6 party for that. Mr. Tucker, I don't know if the appellant was intending to respond to that, or whether you're going to cover that in closings, or.
No, if I can just say one thing briefly in response, sir. We did muse about putting in a response, but essentially we've decided not to. We think that the debate on that is probably clear to you, sir. That note appears to come from a misunderstanding of what our note was intended to do. Our note was not intended to be scenario 1. Our note was to be scenario 1 having regard to the tie-in which has now been constructed and adopted at the end of phase 1, and how that has to be brought through to comply with relevant highway standards, etc. That appears to be a misunderstanding on the part of the note that's coming from the third parties. Other than that, sir, happy for you to form a view on the information that you have before you.
Okay, thank you, Mr. Tucker. Anything final to say about Mr. Neil?
No, sir.
Happy to move on. Thank you. Okay, and then I've had a letter added as ID 36 from a Mr. James. I wasn't expecting or inviting any further written representations, but I decided, as I hadn't made that clear, I would accept this one. I'm certainly not expecting or inviting any more, and unless there are exceptional circumstances, I certainly won't be accepting anything more after today. Any comments from the appellant, given it's obviously an objection, Mr. Tucker? Anything you want to say about it or not?
No objection to your receiving it, sir. In the circumstances, that seems entirely sensible.
Okay, thank you. Unless there's anything more to say on that, we'll move on to a couple more documents. So the draft conditions schedule has been added as ID 37, which I have gone through, and I have made some comments which we'll discuss shortly. And then the final thing to mention, for now at least, is the court judgment, the Fides Estates judgment, has been added as ID 39. Mr. Tuck, I think that's come from the appellant.
It has, sir. You'll recall that was actually a footnote in the opening statement referencing forensic archaeology. We thought we put it in when we checked the ID documents over the weekend. It turns out we hadn't. That's our omission. It's all familiar stuff. I think it's paragraph 56 is the relevant ones that talks about whether a policy is ambiguous or obscure, which you may recall from cross-examination.
Okay, thank you for that. I assume that's, there's no objections to that from the other two parties to that going in. Are there any other documents that, apart from closing submissions, any other documents that are intended to be submitted today? Anything else from the appellant, Mr. Tucker?
No, sir. Thank you.
Okay, Mr. Morgan, anything from the council?
No, sir, not that I'm aware. No, nothing from me.
Okay, thank you. Mr. Neil, anything from the Rule 6 party?
No, sir.
Thank you. Are there any other procedural or housekeeping matters from anyone at this point? Mr. Neil, is that a hand up?
Yes, so I won't use my yellow virtual hand.
Okay, go on then.
So you asked last week about the drone footage that had been submitted, and if I could, I have got clarification on this, sir. So
Okay.
what you've received, and this is all agreed, at least in terms of them going in as ID documents, all agreed with the appellant. You have ID 27 and ID 28 are the actual video clips.
Yes.
Then the stills that you've received, which I think is what you are ID 29.
Yeah, folder.
Yes, those are simply the stills that were taken during the drone survey itself and referenced in Mr. Bales's report.
Right.
They are not, just to be clear, they are not the agree or the times that the experts, Mr. Pinto and Mr. Russell, agreed that you should pay particular attention to. That they are that's separate. You received an email, sir, from Miss Fraser on behalf of the appellants, setting out the times for you to have for you to focus on in terms of some 2-minute snapshots, and those are set out in an email to Mr. Salter at 3:04 p.m. on the 3rd of February.
Okay.
Those are totally separate to the still shots that you've received at ID 34. They're not ID 29.
I see. Okay.
So I just wanted to clarify that.
Yeah, that's helpful. And obviously, yes, that I have seen that email from Ms. Fraser, so I'll make sure I reference that when I'm assessing it. Thank you.
Thank you, sir.
Thank you, Mr. Tucker. Anything else?
Sorry, sir. For some reason, my mouse disappeared. Firstly, on that point, sir, no objection to your seeing it. These are photographs that have been in the public domain for some time, and obviously, Mr. Pinto and the rest of the appellant's team will have had sight of them. In relation to the reason for my raising my hand, sir, there was one additional document you've not referenced, sir, but I understand has been circulated to the parties, which is the heights document that Mr. Frampton read out last week during the course of his evidence. Which I don't think has yet made its way onto the list of conditions, unless I've missed it.
I don't think it has. I have seen the email from Mr. Frampton with the wording for the condition, heights condition.
I just wonder, sir, whether it's sensible for us to just add that as an ID document so that everybody can have sight of it.
We can do. I suppose we're going to probably talk about it very shortly. So it may or may not survive in that form of wording or for very long, or it may be agreed and we can add it as an ID document. So yes, I think let's put it on sort of on the provisional list for adding to as an ID document. I suppose it depends whether how many other changes to conditions might be necessary after our discussion shortly. Hopefully not very many. But
of course, I'm just thinking about convenience. That's all.
Of course, no, absolutely. We'll make sure whatever happens, we'll make sure that that wording is in the public domain. However it's done.
Thank you, sir. Ms. Fraser's on the call. I'm sure she'll put it up as soon as she can. Thank you.
Yeah, so that's fine. Thank you. Anything else from anyone? If not, then we'll move on to the conditions on 106 discussion. I was going to propose we did conditions first and then 106, unless anyone has a burning desire to switch it round the other way or has availability issues. I'm hoping that neither will take too long, but if we're happy, we'll start with the conditions. In terms of who's speaking on this for each party, presumably obviously the barristers will be on hand for any technical legal points, but in terms of general points, is it Mr. Griggs Trevelyan for the council? Yeah.
It is, yes, thank you.
Thank you. And Mr. Frampton for the appellant?
Indeed, sir. Thank you.
Hello. And for the Rule 6 party, Mr. Neil, would it be you or would it be Dr. Garnett and Mr. Ostwig as needed?
I think the latter, sir. As you're aware, the Rule 6 party is a double-headed beast. So Mr. Ostwick and Mr. Garnett are available. So I will chip in if necessary, but they will also wish to contribute.
Thank you. I see they're both in the call actually on the same. In fact, they are both.
Yeah.
Hello, Mr. Ostwick and Dr. Garnett. And obviously, anybody else who feels that they need to chip in, then obviously just raise your hand if needed. What we'll do is we'll go through the conditions in the schedule, and we won't. I don't intend to go through every single one. There's been quite a lot of amendments made, which have answered a lot of my queries, which is good. Thank you. So we'll just focus on ones which relate to sort of plans or the SMC issue or any overlap with the 106. So without further ado, we'll make a start on that and start off with condition 1, which sets out all the plans relevant to the outline permission, the various parameter plans, all of which I don't think are controversial or disputed. But there is the question about the master plan, and I see that both the council and the appellant consider it should be an approved plan. Whereas the Rule 6 party have some concerns. I think is that fair to say, Mr. Ostwick and Dr. Garnett?
Yeah, that's absolutely right. And I'm entirely sure what the consequence is of including them as an approved plan in relation to the placemaking principles.
Okay, thank you. I think so my point of view, obviously thinking about the 6 tests that conditions have to meet, and I want to know, I would be curious to know if it's necessary in particular to include the master plan as an approved plan. I don't know if, in particularly when we obviously we have the parameter plans, and it's whether or not the master plan adds anything or has anything that needs to be included that isn't reflected in the parameter plans. So I suppose I'd be curious for the appellant or the council's view on that. Mr. Griggs-Trevalen?
Yes, sir. So my view on this is it's a fairly sort of marginal point, and I think you wouldn't necessarily take objection to it being removed, but I think it is helpful in that the master plan is a sort of summation of all of the parameter plans and helps with the interpretation of those parameter plans as a whole. And given there will be a need for reserve matters, applications should consent be allowed, then I think having that there is necessary for the overall interpretation of the parameter plans. That's my view, but as I said, I wouldn't take too much of an issue if it was gone.
Okay, thank you, Mr. Griggs-Trevalen. Mr. Frampton, firstly, did you want to add anything to that?
Indeed, so I agree with Mr. Griggs-Trevalen. The master plan is effectively the product of the placemaking, the parameters plans. And also we've got reference in the policy to the master plan being agreed, and the only way it can be agreed is through the development management process. So it does seem to me to be appropriate that it is so defined.
Okay, Mr. Neil, I think you had your hand up briefly.
Yes, sir. I don't want to repeat what will form part of the substantive submissions on this issue when it comes to closing. And I've noted what Mr. Frampton said there. I mean, we note that the council's saying it's not absolutely necessary. That means it doesn't meet the Newbury test. So we still, it's not a summation at all of the parameters plans. In fact, quite the contrary. And our case is the parameters plans are sufficient for this application. So I'm afraid none of what we've just heard justifies the inclusion of this as an approved or conditioned in this way as an approved document. So I just want to make, before we move on from this issue, make sure that in doing so, the Rule 6 party's case on this is absolutely is made clear. We'll address this in closing, but it goes to the heart of the problem with we say with the lack of compliance with that placemaking principle. But specifically, as I say, just to repeat, what you've just heard means that it is not necessary to include it.
Okay, thank you, Mr. Neil. Mr. Tucker?
Yeah, a couple of points. Mr. Neil made reference to the Newbury test. Obviously, necessity isn't past the Newbury test, having spent some time in the Court of Appeal on that one. It is, however, past the SIL-REGS test, and it is obviously a policy test. But that's the geeky planning point. The substantive point, sir, is from our case, we say that there is a policy justification for there being an approved master plan, hence the reason why there's a master plan that we say ought to be part of condition number 1. And my recollection is Mr. Griggs-Trevathian did say that it was a marginal issue, not that it wasn't a necessary issue. But happy to leave it to you, sir, in terms of your view of that. And you'll obviously form your view on what Mr. Frampton has to say. And I look forward to responding to what Mr. Neil has to say in closing in due course.
Okay, thank you. Anything else on the master plan point? Thank you. Obviously, as the parties have indicated, it's yes, it will be a matter for me to form a view on based on closing submissions and all the evidence that I've heard throughout the inquiry. Thank you. Then it might be a good time at this point, just because we're dealing with plans, to raise Mr. Frampton's email about the building heights parameters plan. So, Mr. Frampton, you've provided a condition which says that notwithstanding the provision of that plan, which identifies a maximum ridge height of 14 metres above ground floor level within the zone described as up to 3-storey. Notwithstanding all that, the provision of any dwelling with a ridge height in excess of 11 metres above ground level within that zone shall only be determined through the submission and approval of reserved matters. Does this cover your point, Mr. Frampton, about having control over that?
It does indeed, and obviously it's a condition I drafted without prejudice to the appellant's case, but again, a matter for your judgment. If you were concerned by that provision on the building height parameter plan, it seems to me that is a lawful planning condition to be, obviously for the barristers here to comment, but a lawful planning condition to ensure that control rests with the planning authority when they consider the submission of reserved matters.
Thank you, Mr. Frampton. Mr. Griggs-Trevathian, any comments on that?
Yes, sir. We have some issues with the wording of this condition, and obviously, again, everything without prejudice to the council's case. But my reading of this condition basically suggests that it's only buildings that are above 11 metres that would be subject to the submission approval of reserved matters, when in fact all of the buildings would necessarily be subject to the approval of reserved matters. And in some respects, by suggesting that notwithstanding the building height parameters, that actually is a less constrained approach to the building heights than if this condition were not included, because it's suggesting that you ignore the building heights parameters for those taller buildings, and they are just determined through reserved matters, rather than having a parameter for which is a sort of maximum parameter. So we have some concerns about the wording of this condition and how it would work in practical reality. And also, once you start sort of messing with the parameter plans, there's consequential things that would happen in terms of how would you address the other parameters and things, So okay. We do have some concerns about the wording of that.
And is it something that, well, I'll come back. I'll let Mr. Neil for the Rule 6 party chip in as well. Mr. Neil?
Yes, sir. We broadly endorse what Mr. Griggs-Trevathian has just set out. Just to give some context to this, so we received this at 4:55 last night. I gather it's been with the force. It's been circulated earlier to the council. I don't take particular issue with that, but it doesn't. There are two particular concerns with it. You've got the concerns that Mr. Griggs-Trevathian's already said, but it doesn't actually work as a condition. We just don't understand what it means. It says notwithstanding, if I'm looking at the right document, which is this email circulated on the 6th February 1553 to Mr. Greg Trevarthen.
That's the one I have, yeah.
Yes, it says notwithstanding the provision on the building heights parameters plan within the zone, etc., up to 3 stories, the provision of any dwelling with a ridge height in excess of 11 meters above ground level within that zone shall only be determined through the submission and approval of reserved matters. I mean, I just don't understand what that's trying to achieve, because the buildings are going to have to be determined through, or any provision of any dwelling is going to have to be determined through the provision of reserved matters, unless I've completely missed something. So we don't really understand. It doesn't work it doesn't make any real sense as a condition, and we're not quite sure what it's really trying to achieve. And if it is trying to put a further constraint on maximum ridge heights, which we don't think it is, but if that is the real purpose of this, then that we don't understand on what basis 11 meters has been chosen, or in fact why it shouldn't be 9, 10, or whatever. I mean, this should have all been set up much earlier. If that is the case, the appellant's case they're putting forward, that should have been set out much earlier and way before this inquiry, and then subject to assessment. But as I say, the main point is it doesn't make any sense at the moment, as far as I can see.
Yeah. Thank you, Mr. Neal. I'll see what Mr. Tucker has to say, and any comments on the wording. Well, Mr. Tucker.
So first of all, timescale, this is the same text that was read out by Mr. Frampton at the inquiry last week. I don't know why it didn't get to my learned friend until yesterday evening, but nonetheless, it's certainly something that everybody's had notice of. Secondly, this is not our case. This is in the event that you, sir, had a concern with regard to the view from the south, and you'll recall the maximum parameters height in the red dotted line that you were taking to during the landscape evidence, and that you thought that notwithstanding the acceptability of development in that area, that there was a need to control height in addition. The intention is therefore to add an extra level of control in addition to reserved matters. I think Mr. Griggs-Trevathen has got a point that the way it's worded at the moment might lead to the conclusion that somehow that's a relaxation with regard to height. That's not the intention. I think it's fair to say we haven't had any feedback until now. It's maybe a point the planners can have a think about behind the scenes, because the intention is to add an extra layer of control. And in relation to the actual height that's been referred to, if one looks at the height parameters plan, it specifies that 11 meters is intended to be the 2.5 story height rather than the 3-story height. That's where that figure comes from, and that's consistent with what Mr. Frampton said last week. So yes, it's not intended to relax controls in that area. It's intended to add controls, hence the reason why it starts with notwithstanding. But in terms of process, my suspicion is that that the Rule 6 party and the council would prefer there to be greater control in the area which gives rise to greatest height, notwithstanding that Miss Prescott, in her case, didn't think that it was necessary. But it may be a matter that Mr. Frampton and the other planners might wish to liaise upon behind the scenes whilst the barristers are wittering on with their closings. I don't know. But so the objective is that. I think the objective is clarity. In terms of the text, that might need a little bit more tweaking.
Okay, thank you, Mr. Tucker. Mr. Morgan?
Thank you. I'll try not to witter too much. I'll take it in the spirit, we all know. I was just going to say, yes, I mean, I have no objection to further consideration, but I would make this point, and again, without trying to preempt my closings, if it is intended without prejudice, one of the approaches would be to limit the height, the maximum height, then that ought to be stated. But the concern arising from our cases, so you're not in a position to do that, and I don't mean that rudely, but you don't have sufficient information in which to assess what the appropriate height limit would be, and also to take into account at the same time the numbers and areas covered by the development, which is also a concern of ours, as you know. We don't have that information for the reasons I'll make submissions on that you've heard. So with respect, I mean, yes, it might be that there might be benefits from a height limit. The problem is I don't think we're, with respect, have the information to conclude that when you combine that with the extent and numbers of the development as well. But that goes to the root of the case, and I will stop there. But I just wanted to make that point in light of what Mr. Tucker said.
Okay, thank you, Mr. Morgan. Mr. Tucker?
You do have that information, sir, because the the red line on the viewpoint, I forget which number viewpoint it is, 22 from recollection, does show the maximum parameter height for the 2.5 story. And then you'll recall it steps up. That was a point I put in cross-examination. So you can see on that the dotted red line where the 2.5 story is, and that's reflective of what's in the condition. But that's probably started to transgress into both minimal and a friend's wittering. So I'm happy to leave it there, sir.
Okay, thank you. Anything else to say on this condition? I think if Mr. Frampton, Mr. Griggs-Trevelyan and representatives from the Rule 6 Party want to discuss the wording of this condition behind the scenes whilst submissions are being delivered, then I'm happy to pick this up at the end before we close today. Revisit this. I think I can see that there are issues with the wording, and there certainly needs to be some clarification as to what's intended in the second part of that condition. But I think rather than take up too much time now, if I could leave that with the planners and others to discuss. Thank you.
Thank you.
The final thing I suppose is I think obviously there is no condition being put forward by any party about restricting the number of dwellings. It's a point that's been raised during the inquiry. I'm assuming that hasn't been discussed or put forward at all in any shape or form, Mr. Griggs-Trevelyan or Mr. Frampton.
Well, we did. I turned our minds to it following your comments, sir. And I think the issue with restricting the numbers, I'm sure there's probably more issues I haven't thought of, but is the consequential amendments that would then be required to all of the parameter plans. So if you were to limit the numbers to 150, for example, then how would that then work with all how would the extent of development then be defined within all the parameter plans? What would that do to the density? How would that sort of operate? And I think it's fraught with practical difficulties there. So, and it's my understanding the appellant's cases as well. They wouldn't seek to accept any condition around limiting numbers either. But I'll let Mr. Frampton speak on that.
Thank you, Mr. Morgan. Do you want to add something before I ask Mr. Frampton?
Endorse what Mr. Griggs-Trevelyan said, but from our perspective, that would yes, our case is on the alternative, the more we say policy compliant in terms of numbers. But so it seems to me that would be too major a change, quite frankly, certainly at this stage, to the proposals in the way that Mr. Griggs-Trevelyan said. I'm not sure it would be lawful or appropriate to do that at this stage, but that's our concern, sir, about that.
Okay. Thank you. Anything from the appellant in response?
Thank you, sir. I agree with Mr. Griggs-Trevelyan on the sort of practicalities, but fundamentally, we say this is not a case about numbers. It's a matter of the effects of development, and therefore there is no justification in a condition that restricts the number of dwellings.
Okay. Thank you. Anything else on the question of numbers, Mr. Tucker?
Yeah, just briefly, sir. Once my learned friend mentions the word unlawful, that's when my ears prick up. I think the issue would be, sir, that if you consider that the council's case was right, that there should be a maximum of 130 to 150 from Ms. Priscott's evidence. Her case isn't just numbers. Her case is effects and disposition upon the plateau. So it would be difficult for you to essentially say, no, it was acceptable based upon the parameters plan to have a lower number. Ms. Griggs-Trevelyan makes reference to the issue of density. That would also be an issue. I don't think anybody's calculated what the density is on that basis, but it would be obviously a bit less than half of what the current density is and probably therefore outside the range within the policy. Strictly speaking, within the Wheatcroft principles, and you'll recall, so the Wheatcroft case was, I think, 390 houses, and the court said the Secretary of State could have consented down to 220. Within the strict parameters of the Wheatcroft case, I think you could do it. I think in these circumstances, it will be profoundly difficult to do so. And certainly, were that something that was on your mind, sir, when you come to consider matters, I think it's probably one of those cases where you need to revert back to the parties and seek their views. So a slightly caveated agreement with Mr. Morgan there, but I don't think any party's case, in fact, invites that conclusion. But if you came to that conclusion, so I think in the interest of all parties and the interest of justice, it would be a reversion case.
Okay, or me saying you need to go back to the drawing board.
Well, yes, or a dismissal case. That's obviously right. I mean, the other point, sir, is that the technical point. Could you condition the numbers? So one would have 290 within a condition rather than the description, but my anticipation is that's not what you're really thinking, sir. But if it was, yes, you could, and certainly we'd have no concern about adding a condition which restricted numbers and then deleting that from the description of development. Were that to be a conclusion, that plainly doesn't prejudice us at all. In fact, I can't see anybody would be prejudiced by that.
If yes, obviously my conclusion was that up to 290 dwellings was acceptable. If that was my conclusion, yeah. Of course, and obviously at the end of the day, the words up to don't require 290 to be delivered.
Precisely.
Anything else to say on that? Anything that last point about a condition for up to 290 dwellings, Mr. Morgan?
I may have missed it. So I think I agree with what the learned friend, certainly up to that point. All I would say is if you have an up to, obviously it allows that number to be accommodated on the site.
Yes, of course, which is in the council's case.
Yeah, exactly. And one has to assess, obviously, the implications of that, which I know is being done. So thank you.
Yeah, okay. Thank you. Anything else to say about the question of numbers and condition? Okay, if not, then we'll move on. That's probably the longest condition one discussion I've had for a very long time about plans, but thank you. It's been very helpful to have that discussion. I don't have any comments on condition 2 on time limit. This is all reserved matters, so time limit for reserved matters, or the details in condition 3 or 4 regarding design quality, but do shout if anyone does. Then there's condition, there's double condition 4. I hadn't spotted that. Oh, well, not to worry. The second condition 4 is about levels, and no comments on that. And then condition 5 about allotments. There's now a retention clause and a clarification about carrying out the details and approval with reserved matters. So that all seems fine. Condition 6 is about drainage strategy for the outline application. Had no comments on the wording there. Condition 7 on lighting, we have a bit more text that's been altered. I asked the question about whether or not it was necessary to have the local planning authority approval, given this was a reserved matters point, like condition 6 and other conditions. And I suggested about wording being consistent with condition 6 and other conditions about it being in line with the approved reserved matters. There's been quite a bit more technical stuff added to this condition, I think, by the appellant, and the council has suggested amendments to take out wording about this. This is about it needing to be approved in a kind of separate way. Mr. Griggs, first of all, do you have any comments on the? I think you said you're satisfied with the additional sort of technical points in this condition.
Yes, I think they just add clarity and pick up some of the points around the lighting zones, E1 and the target levels for lighting, which are perfectly acceptable. Add a bit more precision. On the point around the to be submitted approved by the local planning authority, I did take that out. The appellant asked for it to go back in. They felt it was clearer that way. I have no strong view on it, as I think it does talk, it is part of the reserved matters application, and whether those words imply some sort of separate approval process. I assume that was your concern. If that is the concern, then I'd be happy for those words to be taken out again, because I feel it sort of works either way. But yeah, that's a question for the appellant, I guess.
Okay, Mr. Frampton, is the appellant still seeking have those words reinstated to be submitted and approved?
We are, sir, because the significance of the lighting levels in terms of protecting bats, to have a specific approval under this condition, we think will be beneficial in terms of further applications that we need to submit to Natural England on that.
So more significant than, say, condition 6 on drainage, for example?
Yes, yes, indeed. Yeah.
Okay. Mr. Tucker, do you want to add something?
You're mute, Paul.
I am, sorry. Very small point, sir, which is the reference to E1 may be opaque, if you forgive the pun, for anybody coming to this condition that's not listened to the debate. So I do wonder if the correct reference as to where E1 comes from needs to be referenced, as with you referencing a British standard on trees, which I think is the recommended practice for exterior environmental lighting, but no doubt we can add that behind the scenes. I just don't think it will be clear to somebody else in the future if they're not a lighting engineer.
Okay, yeah, that clarification can be added. Yes, I suppose because this condition is worded very similarly to the other reserve matters conditions, it requires any application to be accompanied by a scheme that deals with all of this. And there is the wording at the end of the policy that says no new external light. So the lighting scheme shall be installed, maintained, and operated thereafter in accordance with the details approved as part of the reserve matters. So there's certainly a need to deal with lighting at the reserve matters stage. But obviously, Mr. Frampton, you're saying you think it needs to go further than that and needs to have some kind of separate approval process.
That would certainly be beneficial. Yes. Yeah.
Okay. And how would that work in practice? Because obviously you'd add the scheme with any reserve matters application. That reserve matters in theory gets approved, but are you saying that there'd also need to be a separate approval for the scheme itself?
Yes, indeed, there would be a separate discharge of condition pursuant to the requirements of condition 7, which we could then present to Natural England.
Okay. Mr. Griggs-Trevelyan, any comments on that?
Yeah, just reflecting on that, I ponder what would then be different about the application submitted at the condition stage, unless it was intended that it might be that there's some update provided at the sort of condition discharge stage beyond that was submitted at the reserve matters stage, because the details of the condition requires the same level of detail in both submissions. So if the idea is to provide an opportunity to update just prior to commencement of development, and that's something that's necessary for Natural England, then I agree with Mr. Frampton. But if that's in practice only going to be a resubmission of the same information we've received at reserve matters stage, then I don't necessarily see the value in that.
Does it act as a sort of trigger point that the lighting scheme, the first paragraph acts as a trigger point that that you can't get as far as applying for reserve matters without providing a detailed lighting scheme? So that first paragraph in that condition acts as that sort of trigger, Mr. Griggs-Trevelyan, and then ordinarily that would then just be dealt with through reserve matters, but here there is an additional discharge that the council would need to provide. But you're saying, is that necessary?
Yes, it's whether we deal with it as part of the reserve matters application or as something separate, and or whether that's something separate is submitted at the same time as the reserve matters application. I mean, I'm not one for having duplicate processes running at the same time for no good reason. If we can deal with it as part of the reserve matters, which seems entirely sensible to me, then it should just be part of the reserve matters application.
Okay, thank you. Any response, Mr. Frampton? Or is it see above?
We do see utility in having a specific discharge of condition 7 rather than just providing the approval of which may not be clear to Natural England that the prescriptions of this condition have been fully discharged. So that's the difference between us on that.
Okay.
And I've got
Specifically
one other point, so if I may, on this condition, whenever you're convenient to you.
No, yeah, go on, make that point.
It's the last paragraph above the reason, which says no new external lighting, including private lighting. And it seemed to me the phrase private lighting was perhaps a little obscure, and it seemed to me it would be better to say no external lighting affixed to any building or structure, so that it's clear as to what it's directed to.
Okay, any comments on that, Mr. Griggs-Trevaldhen?
No, the council are happy with that section, so we've got no issues with that.
And the essential point is that individual householders shouldn't be able to suddenly put up massive security lights and so on without obviously first getting permission from the council. So it's clarifying that.
Yeah, and we have used a similar condition in sensitive areas before, such as this. I appreciate it may seem quite onerous in some regards, but we are, I think all parties have accepted the high sensitivity of this site, both in terms of its ecological sensitivity and its landscape value being in the OMB. And so in that sense, we believe it's justified. And the additional wording of private lighting is just helps provide clarity.
Okay, but council has no problems if it's affixed to any building or structure.
No, that's fine. We would be able to identify, new lights that appeared, particularly if they're, causing a problem. That would be something we could identify and therefore take enforcement action against.
Yes, I see that comment there. Yes, thank you. Okay, anything else to say on this condition from anyone in terms of lighting? If not, then moving on to condition 8, I think there's been some changes made in line with my comments and reference to condition 17 in terms of implementation. So that's all fine, thank you, unless anyone has anything. Condition 9 on sustainable construction, I think again there's been some minor changes, so that's all okay. Condition 10 on sustainable construction compliance, there's been a minor amendment to that to clarify the tables, and also explanation of why a retention clause would not meet the test, which I understand the point being made and don't have anything more to add unless anybody else does. Condition 11 deals with phasing plan. That has had some changes to clarify when that should be submitted, so that basically any application for reserve matters should have a phasing plan, so everyone knows what's being dealt with. Just wondered whether there was slight yes, the brackets in the text, I'm not sure if that makes sense when you read it through the whole sentence through, because it says at the moment, it says any application for the reserve matters shall be accompanied by a phasing plan defining distinct parts of the development, including parks and recreation areas, play facilities, footpaths and shared use paths, and the order in which these will be delivered. And then in brackets it said, or any revised version of it submitted to and approved in writing by the local planning authority. I'm just not sure the brackets makes sense. I wonder whether it needs a new sentence that says that the plan or any revised version of it shall be approved in writing by the council before or alongside any reserve matters approval. So it's I'm not sure, again, maybe it's something behind the scenes to look at, Mr. Griggs-Trevaldhen, but that brackets didn't quite make sense.
I think the intention, sir, was to require reserve matters a phasing plan to accompany any reserve matters, and then subsequent to that, if that phasing plan needed to change, to allow that to happen through a discharge of condition process or something similar to that. I agree. There is some awkwardness to those brackets and how that's worked. So I'm happy to give it some more thought and to have a chat with Mr. Frampton about that. But I don't know if he's got any comments.
Yes, so I'll pick that up with Mr. Griggs-Trevaldhen in a break or in the closing and come back to you.
Thank you. I mean, maybe the word "or" at the start of that brackets doesn't quite make sense. It may be any, if it's the intention about revised versions, then maybe just need to maybe just clarify what's meant by the revised version.
Could be as simple as you say, a new sentence, and just says any revised version of the phasing plan shall be submitted to and approved in writing by the local planning authority.
Yes,
as a separate sentence in there.
Yeah,
but we'll give it some more thought. So.
Yeah, and obviously, if it does say that, then obviously there needs to probably be some time scale on that. So you couldn't put it in a phasing plan, 2 years into construction of the development. You'd have to say it would have to be done, presumably before all reserve matters were approved or something along those.
I think, well, unless I'm missing something, so I think the intention was that it would allow that flexibility. It's, as construction goes on and things change, and they might need to deliver certain phases in a different order. That it would allow that to an application to discharge and to seek a new phasing plan to be submitted to the local authority. Obviously, we're not under any obligation to approve any revised phasing plan. So there would have to be a justification, etc., for that. But that was sort of, I think, the intention.
Okay, I can understand that logic. Anything else to say on that condition from anyone? No. Okay, then thank you. Condition 12 to deal with construction management plan. No comments on that. The condition 13 on the construction and environmental management plan. There's been some agreement between the council and the appellant on the wording, so that is fine. Thank you. So moving on, then condition 14 deals with the bat and wildlife mitigation and compensation scheme. Obviously, we're in the 106. There are references to some of these matters like skylarks and reptiles. Just want to understand the purpose of this condition alongside what's in the 106. I don't know if Mr. Griggs-Trevarthen can assist.
There is, I believe there's some duplication, but I think the way it's structured, possibly not. It's difficult for me to talk about the section 106 and the conditions, how they overlap. But there is, I believe this is to ensure everything is captured. I think there might be some cross reference to some of these measures in the 106. I don't know if Mr. Frampton is able to assist me a little bit on this one.
I'm going to pass the baton to the consultant from Kestrel, if I may. If they could join this session. Yeah. Lynn? Is she not there?
We can come back to it with the 106 if you.
Yes, okay, we could do that. We'll do it that way. So,
your colleague can be sort of alerted to the query. I think he's conscious that conditions and obligations shouldn't repeat each other or duplicate each other. So that was my question here, really. So
so it may, sorry to cut across. It may be that this is to do with because this obviously will cover. This is for the outline consent section on the outline land. It's obviously not related to the land outside of the appeal site, which does include in the 106 does include some land outside the appeal site, which is bound, and it might be that there's some distinction there, but we'll have to check when we get to the section 106 stage. So
okay, thank you. Well, yeah, we'll park that for now. Then I think probably condition 15 there might be sort of similar query and maybe a similar answer about the kind of what the 106 requires and what this condition requires. But again, it may well be, as Mr. Griggs-Trevarthen says, about the difference between the outline consent and the wider purview of the 106. I see you're nodding. So
yeah, I believe that's the case. Yeah.
Okay. Fine. Well, we'll come back to these points in the 106 discussion. Then condition 16 on ecological and biodiversity net gain compliance report. There's been some minor changes there. So nothing more to add. Similarly with condition 17, some clarification provided on landscape implementation. Then condition 18, road conditions survey. Thank you. I think the additional wording about how that should be carried out, I think it's helpful. I think otherwise it wasn't particularly clear as to how that might be achievable. So I think the additional wording requiring survey work every 12 months following the approval of the survey until the development is completed, I think helps. And I see that the appellant has no objection to that. Condition.
Indeed.
Thank you, Mr. French. Yeah, thank you. Yeah, condition 19. There's been some clarification about the trigger for submission of a scheme. Apart from a typo where I think the track changes, it works on the affected part of the site. I think it's the wrong affected. It's A rather than E, but that's my pedant in me. That's the only comment I had on that. Condition 20 about the arboricultural method statements. There's been a merger with that and condition 23. So that makes sense. Clear that it's all in one condition. Condition 21, the council has responded to my query about the necessity of this condition, saying that it wants that control up front rather than at reserve matters stage, or rather, it's something that needs to be dealt with in its own right. Is that correct, Mr. Griggs-Trevelyan?
Yes, I think our view is that given the aspirations for design quality that have been set out, our view is this having a schedule of materials and finishes will be essential, and along with all the details in the rest of the condition. And so even though some of that information might become forthcoming at reserve matter stage, I think it's very likely we would require this condition in any case, and therefore it just makes sense to put it on now. If you come to a different view, sir, and you decide it's not necessary now and we can do it later, then that is also fine. But my view is you can foresee that this will be required, so it should go on the outline.
Yeah, thank you. And I think the same point is made for condition 22 and the new 23 about sample panels and footpaths and so on. Yeah, I see the appellant has no objections to that.
No objections, sir. Thank you.
Okay, thank you. So there's nothing else on materials or the other conditions on sample panels and dwelling access. Then we'll move on to condition 24, which has been clarified in terms of retention clause and removal of a tailpiece, which addresses the comments I had. So I'm happy to move on from there. Condition 25 on waste management, no comments previously, and that's still the case. Condition 27, as was, has been deleted. I asked whether or not it was necessary to have a condition regarding internal noise insulation, and Mr. Griggs-Trevelyan has clarified that no reasoning has been given for that from the environmental health officer, so that condition has been deleted. So I assume that's still the case, Mr. Griggs-Trevelyan.
Yes, that's correct, sir. And obviously, tranquility of this site has been mentioned before, so I think that it is plainly clear that there aren't really any obvious excessive noise sources that are going to impact on the occupiers of the development. Okay,
thank you. So unless anyone has anything else to say on that, we'll move on. Condition 26, newly numbered, deals with housing accessibility, reference to the building regs. That's all in agreement. Then we come to condition 27 on the Wansdyke crossing. So obviously we had discussion on this during the inquiry. I assume there's no further update on the scheduled monument consent application, Mr. Frampton?
None that we've received from Historic England, sir.
Okay, so I think obviously the main point of dispute between the parties here is obviously whether or not development should commence before such a consent has been obtained, or whether it should only be required to be in place or be issued by the time the first dwelling is occupied, or no occupation should take place. I guess it's a question that it's a bit of an unknown answer, I suppose. How long is it likely to take to get any decision for scheduled monument consent versus the approval of any reserve matters applications? Because presumably development can't commence until reserve matters have been approved and any pre-commencement conditions discharged, Mr. Frampton. So, do you get any sense from Historic England how long it might take to get that consent?
If the pattern follows the earlier scheduled monument consent, I think we would anticipate receiving it within the next 3 weeks. It's that sort of order.
Yeah, which is not obviously would not be the case in development. Yeah, the development itself is, in terms of actually starting it, commencing it, is going to be some way off. But 3 weeks.
Indeed, it is. Yes, yeah. It's more. My concern is more the principle of this condition being pre-commencement. Is it in response to paragraph 7 of the PPG 21A 007 2018 0615 so fundamental that in the absence of the condition, permission should be refused? Is
that the advice on Grampian condition?
Yeah. Yes, that's right. Use of pre-commencement conditions.
Yeah. Well, yeah.
And our position is that the link, while certainly beneficial, is not so fundamental as to satisfy that guidance, because we say the site is sustainable in terms of its connectivity by active travel by other routes, and that's evidence of Mr. Pinto and in my own proof, which, as far as I'm aware, was not challenged.
Okay, thank you, Mr. Neil. You have your hand raised.
Yes. I mean, it will come as no surprise to you that we entirely disagree with Mr. Frampton suggesting it's not fundamental. I mean, you'll have you would have heard the evidence of Mr. Frampton talking about connectivity to the north of the site. It is a fundamental provision to meet a number of policy requirements, we say, in the plan. It is concerning that it is that there is an attempt to try to limit this to only being supplied prior to first occupation, by which stage the principle of development would have been established through the built construction of it. So we say, given the criticality of this, it should be a proper pre-commencement condition prior to the commencement of any development.
There's no halfway house that can be met in terms of some alternative trigger point in between the two. Not sure any thought's been given to that.
Well, I'm not sure. I mean, sometimes one has things like no above ground development, things like that. I can't see what halfway house there could be, given the criticality of this.
Okay.
And I think, and on this, we seem to be, as I understand it, looking at the comments of Baines, we seem to be aligned as well. So,
okay.
I just want to, that's a point of emphasis. I just want to make sure is put across loud and clear from the Wilson Spartans position.
Thank you, Mr. Neil. Mr. Tucker.
Thank you, sir. So one can imagine any number of different mid-grounds that you could look to. I'm not sure that's necessarily a point, because the real issue is ensuring that there is going to be a connection for people who are first moving into the house, rather than necessarily construction workers. That's the only real justification for having it in at pre-commencement. And I'm surprised to hear what Mr. Neil has to say, because at paragraph 687 of his witness's evidence, his witness, Mr. Waters, actually says he agrees the formation of the link should be completed before first occupation. But I accept that Mr. Waters' evidence may be different from Muller and Friends' instructions. But I just draw that to your attention. It's maybe a point to pick up in closing.
Okay. Anything else to say on this? Anything from the council?
So, just to say, just pick up on the last point. I think all the parties agreed it should be completed before occupation, but I think the question is whether the consent, the scheduled monument consent, should be pre-commencement or pre-occupation. Okay. Obviously, the council's view is it should be pre-commencement. We do think it is an important part of the development to ensure that there's compliance with placemaking principles. It's clear, I think, from the parameter plans that it is an important part of the development, connecting the sort of central area to the north and the surrounding facilities. we have similar concerns to the Rule 6 party about any halfway house, because essentially once the idea is it's a true Grampian because it's so fundamental, and you know, whether there's foundations there or a completed building, I think you still end up in the same tricky situation if scheduled monument consent isn't granted. However, the council's case is one of pragmatism, which is we've seen, you know, that as per the guidance on Grampian conditions, we think there's a very good chance that scheduled monument consent will be granted given the advanced stage of the conversations that have been had with Historic England. So,
okay, thank you. On that final point, obviously, if it is, you know, if there is a decision consent issued with a favourable one, obviously in the next or any decision rather in the next few weeks, obviously please let me know. Obviously, you know, it may be useful to know before my decision is issued. So just by all means let me know. Obviously, if consent is granted, as has been obtained, then obviously there's no need to have this wording at all. But you would need wording to say that it should be completed prior to the occupation of any dwelling, but everyone's agreed on that. So the condition would just need to be stripped back to the sort of that second sentence, if that was the case. So yeah, just keep me posted, please, on that. Thank you. And we'll pick up anything on the sort of 106 in the next session, in terms of anything to do with the Wansdyke. Then hopefully we can rattle through the remaining conditions now on the detailed planning permission. So condition 28 sets out the agreed plans. Condition 29 sets out the standard time limit. Condition 30 deals with the works for the development in terms of any sort of timetabling of various ecological survey work, and some changes have been made in line with my comments. There are a number of comments obviously in this detailed permission section, which a number of conditions rather, which are pre-commencement. So I note that the appellant has agreed to most of these, or if not all of these, Mr. Frampton. So I don't know whether
Correct.
if it's wise to put a separate note in to say you agree with all these, or whether that suffices. But you know,
We will do, sir. Yes. Yep.
okay, thank you. There's a construction management plan at condition 31. There is construction environmental management plan at condition 32, and some clarifications being provided about lighting, which makes sense as far as I see it. Then there's a condition on arboricultural method statements, which has been merged again as with the outline condition on the same topic. Then there's a condition on night roosts in terms of making sure that those are in place before any works commence, or in terms of the details have been approved, sorry, before any works commenced, and they have also been constructed at the same time. A bat license information is required. I don't know if this is, again, another case of duplication, which maybe pick up in the 106 discussion about whether or not requiring this by condition is necessary if the 106 also covers it, but we'll maybe come back to that point. Condition 36 on landscape, this has been merged with the compliance condition as well, and I'm assuming it's pre-commencement, Mr. Griggs-Trevelyan, because it deals with landscaping through Sulis Manor. It's presumably the council is seeking this up front because of the nature of that landscape.
Yes, it's because of the nature of the landscape and the fact that there aren't many stages to the development that goes through Sulis Manor. It is a road, and so, you know, obviously preoccupation doesn't really make sense in that context. And given the importance of the landscape and knowing what's going back and how things are going to be finished, I think is pretty crucial at the pre-commencement stage.
I assume the same with lighting as well. That, you know, that it's hard to tie that to anything else. Otherwise, yeah.
Agreed.
Okay. I see the appellant has no objections to those.
No objections, sir. No objection, and I'll cover that in the notes.
Thank you. Then there's a similar condition to the outline about road condition survey with the same amendment. similar condition on unexpected contamination, a condition about drainage strategy, which now has a retention clause, and then just a few comments on. I was asking about whether or not there was conditions needed for a couple of things. The council's responded on the early years provision on that, which I think, in light of the information we have, I had no further comments on that except that response. And then, in terms of the travel plan, I think there is in the 106 actually deals with this in terms of the implementation, monitoring, and review of the travel plan. I think it's one of the obligations in the council's section of the 106, so it is covered there. It's something I missed earlier. So nothing else I wanted to say on conditions, unless anybody else had anything they wanted to raise on conditions. Mr. Tucker?
Yes, sir. Just the issue in terms of bringing the appellant's ecologist on. Apparently, it's an artifice of the town hall approach of Teams that the ecologist is watching as a member of the public, not as a member, as a panelist. But what we'll do is when we turn to 106, we'll perhaps just revisit that one condition Mr. Frampton wanted Ms. Jenkins to comment upon, if that's acceptable.
Yeah, well, we can have if we want to have a short break now, we could do and allow her to join in the call if she needs to be sent the meeting link or anything. Otherwise we can carry straight on with 106.
Happy to carry on and do that in the background, sir, if that would be acceptable.
If everyone else is happy to carry on, we should hopefully then maybe end to break around half 11 if things move fairly swiftly. Thank you. So in terms of the 106, I assume there will be a couple of other people maybe in the call for this section. So this is still Mr. Griggs Trevelyan for the council. Anybody else for the council?
So it'll be Mr. Nigel Hewitson. I think you were sent his details yesterday. He's a solicitor involved in assisting the council on this matter.
Okay, yes, I see Mr. Hewitson's there. Yeah.
And so you will have seen Megan Forms from Messrs. Denton's, who's just come on the call, who will take the lead for the 106 on behalf of the appellant.
Okay, yes, I see Ms. Forbes as well. Hello to both of you. So thank you. Yes, so I now have the most up-to-date version of the draft 106 is dated the 10th of February. And obviously we'll go through this. And obviously, again, if the Rule 6 party have any points they want to raise at any point, just let me know. So we now have office copy entries and maps provided. Thank you for that. And clarification on the third owner as just being Mr. Jamie Rodriguez, Jacob, which I probably terribly massacred his name. Apologies, but we have clarification on him as the owner and the beneficiaries, which there are a number of beneficiaries, which I note from the technical note that they will be signatories to the 106 as a kind of confirmation rather than a necessity. Is that right, Ms. Forbes?
Yes, good morning, sir. I thought perhaps we could start with that. That's a good starting point. I think you've already seen the note we provided regarding the interests. So in short, there's 3 individuals listed on the registered title, 2 of which sadly passed away. We are certain that the legal interest therefore rests solely in, I believe his name's Jaime. So he will be entering into the agreement as the third owner. There are 5 beneficiaries whom which the title will pass to, so they will be entering into on the basis of a sort of confirmatory basis only, just for completeness, but we are confident that they do not need to legally enter into the agreement.
Okay, thank you. And the council have not raised any concerns on that basis, Mr. Hewitson.
That position is acceptable by the council, so yes.
Thank you. And I know we also have a fourth owner, Process Limited, who own some of the land to the south of the hillside, but there is overlap with the southern boundary fence, Ms. Forbes, so that's why they're named.
Yes, so a very small portion of the southern boundary fence falls sort of just south of that phase 1 land, which crosses into the 4th owner's land, which is Process Limited. So for completeness, they are party to the agreement to ensure that they maintain that part of the southern boundary fence falling within their land. So the majority of which falls within sort of the main parcel under the first owner's land, and then some of which falls within the dairyman's land, which is the second owner's.
Okay, thank you. Again, I don't think the council objects So that's our only issue. We have the various title information for them as well. So thank you. So that's just the overview of the owners and beneficiaries. Then the definitions section of the 106. I think my only observation I have now is whether or not there's various points in the 106 where there's reference to detailed and outline elements. Or I think that's referring, when it's referred there, I think it's referring to the application, whether it's for outline or for the detailed plan permission. So I just wondered whether in the definitions it would be helpful to define what is meant just by detailed element and outline element. Just to clarify those parts of the proposal.
So the definition of application contained within the definition section splits into two elements. So there's sort of part I, which then is defined as the outline element, and then part B, which is defined as the detailed element.
I see. Yeah, thank you. Yeah, so that's essentially what I was looking for. I think I was obviously going to the different part of the alphabet to try and find where they are, but they're covered under that definition of application.
Yes.
Great, thank you. I see that. Okay, so then if we whiz through the definitions, I don't think there's anything else on definitions to say. I know there's been a few little changes to some of the opening paragraphs in terms of referencing the third and fourth owners in terms of the overarching 106, and then we get into the schedules. So Schedule 1 sets out various notifications for the first owners to carry out, and then part 1 of that schedule, and then there's part 2 on contributions to various elements. Part 3 deals with affordable housing, and I note that the reference now to the block has been added in the definition of affordable housing, so that's now clear that that's being secured through that.
Yes, we've sort of inserted specific provisions so that the specialist housing block will be offered up to an RP registered provider. If they don't accept, it will be offered up to the council, and then if they do not accept, then it will be provided sort of default social housing units instead. Okay,
thank you. So unless there's anything else to say about affordable housing, we can move on then to part 4, which is green infrastructure. 4A deals with amenity space, parks, recreation and play facilities. Part 4B deals with the allotments and their provision. And then part 4C deals with the Wansdyke Schedule Monument, and specifically the crossing works and vegetation plan. Just to clarify, are the crossing works the same as the Schedule Monument consent application, Ms. Forbes? Is that what the definition?
Yes. So I'm just going to find the definition. The Wansdyke crossing work provisions have been drafted so that if scheduled monument consent is not obtained, then it will default to an alternative route provision.
Yeah. But essentially, the Wansdyke crossing works in the 106 are those scheduled monument consent proposals.
Yes, it means upgrading the footpath of the scheduled monument crossing of the scheduled ancient monument as shown on the plan. So it is.
Yeah. Okay. So that's reliant obviously on the approval process through Historic England and DCMS.
Yes, exactly. And then if that is not successful, then we default to, I think, paragraph 16 onwards is the alternative route provision.
Yes, paragraph 16 says if after using all reasonable endeavours to obtain necessary consents, then various things need to be done in terms of the alternative route. I noticed that obviously the following paragraphs say that there should be an application for the alternative route submitted within 3 weeks of the council agreeing the alternative route, and then where permission for that route is granted, it should be completed within 12 months of the grant of permission. I think the only thing I wondered within paragraph 16, whether there needs to be some timescale for agreeing an alternative route, because it just says there basically the earlier paragraphs do not apply.
So there is, in the definitions, there is an alternative route, and then there's an alternative route plan. So we have a plan appended to the agreement which shows where the alternative route would be.
Yes, so, I've seen that. Thank you. Yeah. I just wonder about because paragraph 17 refers to within 3 months, 3 weeks. I've lost it now. Apologies. Let's get back to where it was. Yes, within 3 weeks of the council agreeing the alternative route. So I suppose it's just should there be a time scale for submitting details of that alternative route? And I just wonder whether.
Yeah, that's fine. We can add that in. I think that perhaps the wording could be clarified a bit, because the definition of alternative route is sort of set so that there is an alternative route in mind. So perhaps it would be to get the council to approve the sort of the form of the planning application as opposed to where the alternative route would be.
Yeah, I mean, agreeing the route is obviously not the same as planning permission in this
case. Yeah.
Mr. Griggs Trevelyan has a point.
Just to say that the route shown on that plan is a sort of indicative route. It's quite a broad line. So I had envisaged that this was to agree more detail, sort of more detailed route with a more thorough analysis, albeit then you need to apply for planning permission for that. So that's the only comment I wanted to add to.
Yes, so I just wondered, does there need to be some wording to sort of say what's expected in terms of submitting a planning application is obviously required, it's likely to be required, but in terms of what and to do that within 3 weeks of the council agreeing of routes, but that's obviously it's a clarification as to when the council needs to do that, or when the appellant needs to provide that information, and obviously whether or not it's done in writing, which I assume it would need to be in writing as well. So I just think there just needs to be some clarification as to the process behind agreeing the alternative routes before then the planning application is put in. So hopefully it's not too difficult to insert some additional wording. But again, it might just be something behind the scenes today to talk about.
Yeah, that's fine. We can discuss separately.
Thank you. Anything else to say on this section on the schedule monument? If not, we'll move on to then. So part 5 deals with targeted recruitment and training. Part 6 deals with a travel plan, and there is reference in a later schedule to the implementation and monitoring of that plan. So that has been covered. There is a slight odd thing here, Ms. Forbes, with the numbering seems to go a bit odd. Each part up until that point has been numbered, starts at 1, and then part 6 starts at 22, and part 7, I think it may just be formatting.
Yes, that's fine. We can get our documents team to get a sort of final engrossment sorting that issue.
Yeah, just take care then. Obviously, like in part 7, where there's reference to paragraph 27A, which I think it should say 28A actually, because 28 has A and B. I think just the final check of numbers and making sure that all makes sense when you come to finalise it. So part 7 deals with transport infrastructure works and access, and I see there's now been splitting those works into 2 parts: the sort of Wansdyke works, if you like, and other off-site works such as the crossing point of Sulis Manor Road, so that is the road into the existing housing development, and the wayfinding for the national cycle route are separated out into one part of works, and the Wansdyke crossing in the second part.
Yes, that's right.
So that's presumably just because of the different timescales involved.
Yes, it's due to different timescales and the control of the land, I think, I understand. So they will be able to carry out the part 1 works which fall within their land, so we can have an occupation trigger on those. But the other works require consent, so we haven't put an occupation trigger on those because that falls outside of their control. So instead we've got reasonable endeavours obligations to enter into those agreements with the council in respect of those works that fall outside of their land.
Okay, thank you. Mr. Neil, I notice you have your hand raised.
Yes, apologies. I think we there was a comment from my client that was, I think they wanted to make in relation to clause 20 under the Wansdyke. Sorry, I know we jumped on.
No, that's okay. I appreciate
there was a bit of a miscommunication between us as to who was going to raise the point. Could I, in fact, it might be appropriate if I could just hand over to, I think, Mr. Garnett, just to make the point. I think it links to clause 20 under part 4C and the provision of the alternate route.
Yeah, okay, thank you.
Are we on?
Yeah.
Yes.
Yep. Hi. It's just reading it. It appears that if the alternate route doesn't get planning permission, then all obligations fall away. Is that what's intended?
So the purpose of that is to ensure that the obligations relating to, so the initial obligations to carry out the Wansdyke crossing works. If that can't be carried out, then the obligations fall to the alternative route.
Yeah.
And if the alternative route can't be carried out, then that paragraph is just to clarify that the obligations relating to the Wansdyke crossing works and the alternative route both fall away because they've gone through the process to try to seek consent for both. So it's only in respect of those paragraphs.
Yeah. So there won't be any route up north then. In fact, no obligation to produce a route up north. Is that right?
I think so. There would be no obligation to provide a Wansdyke crossing or an alternative route.
Yeah.
Which would be possibly to the east rather than the north. But yes,
Yeah.
Is that right, Miss Forbes?
Yes, if they've gone through the process to seek consent via both avenues and have not been able to seek consent either way.
So they would have to use other routes that are already identified.
Yeah, you would. There would be no obligation to provide anything else, Miss Forbes. The existing routes would have to be used.
There isn't currently, no.
No. I see Mr. Tucker has his hand up. Maybe he can.
Yeah, just to make a point, which I suspect will be obvious to you, sir. But the interaction between the conditions on a planning permission and the 106, there are two separate regimes of control. So this doesn't trump the conditions on a planning permission. So in the event that there was no Wansdyke schedule monument consent and no alternative route, that doesn't mean that my clients will be able to occupy the homes, or they would need a further tweak to the permission to be able to do anything with it. And obviously, nobody's going to start building houses unless you're pretty confident that you've got a consent.
Okay, that's helpful. Thank you, Mr. Tucker.
Yeah, that makes sense. Yes, thank you. Thank you. And so, yes, so where were we? I think we're part 7 on the transport infrastructure works and access, which, yes, I think obviously that this section in terms of some of the dedication, Ms. Forbes, that's dealing with the dedication of the footpath route over the crossing, over the monument and through to Cranmore Place. Is that right?
Yes, that's right.
So it goes beyond it's sort of making it formalised public right of way, essentially.
Exactly.
Yeah. Okay. Thank you. And then we then get into a number of ecology and lighting parts, biodiversity again, part 8, the implementation of the habitat management monitoring plan, which is, I think, referred to as is secured by condition. As I say, there are some elements in here where there does appear to be some overlap with the conditions in terms of the biodiversity net gain plan. I think is also required by condition. But I don't know if we've had any updates on that from the ecologists as to why that is the case. If not, we can come back later on if needed on that. But then, yes, if I take the stances, we'll carry on for now. Trees and habitat in part 10, Spine Road in part 11, construction lighting part 12, grassland habitat part 13, southern tree belt management plan and eastern backbarn management is in part 14. 15 deals with the ecological works management plan for the detailed element. Then the bat night roosts deal obviously with what's required at the detailed element stage. And just generally in terms of licensing, again, I suppose this, there is some duplication here, I think, with condition 35 regarding licenses. So because this requires the owner to apply for the license and agree the management plan, etc. And the condition 35 also does the same. So again, if anyone could clarify for me why that is the case, if there's duplication or not. Ms. Forbes, are you able to assist, or do we need the ecology input?
I then it might be the case there's some overlap with sort of certain elements, and that Section 106 is intended to ensure that the maintenance and management of that is secured in perpetuity.
Okay. Fine. Okay. Fine. Well, there's nothing else. Sorry, Mr. Hewson.
Sorry, so just to say, the paragraph 1 of part 16 doesn't require the applicant to, the appellant to apply for a back license. It requires it to notify the council that it has applied for a back license.
Okay,
so
yes.
It's a subtly different point, the only point there.
Whereas this condition, the condition requires something slightly different, presumably. Condition 35 requires a copy of the license issued by Natural England to be provided, and no development of the spine road shall commence until that has been done. Okay, so okay, I can see there are differences between the conditions and obligations then in that sense. Thank you. Then part 17 deals with the safeguarded pedestrian link to facilitate access to Sulis Manor. Part 18 deals with reptile strategy. 19 with footpath works. 20 with the Skylark management plan, requiring that to be approved before any works commence on the outline element. Part 21 deals with outline element highway works, and part 22 deals with outline element ecological works. And again, there's some paragraph numbers that need tidying up as we go through. Then Schedule 2 deals with first and second owner covenants. So the second owners are the people who are interested in Derryman's field. So this is joint obligations there to do with reptile strategy, grassland, biodiversity net gain, and the southern boundary fence. I don't have any queries on any of those points. Schedule 3 deals with the first owners and the third owners covenant. So that's third owner is the Sulis Manor owner, and that deals with bat night roosts, spine road, and spine road lighting plan in that. And I assume that they don't have any ownership over the southern boundary fence. There's no. That's why there's no southern boundary fence mentioned there, Ms. Forbes.
No, no, they don't. It will fall under the Process Limited, I believe, at that point.
Okay, thank you. Schedule 4 deals with the Tynings land to do with the implementation of the Skylark management plan. And then Schedule 5 deals with the fourth owner's land. So this is to do with the southern boundary fence only. And obviously is a separate schedule because they don't have an interest in dairylands. And then Schedule 6 is the covenants for the council, which includes the travel plan and a number of other points that the council would covenant to. And then there are various appendices which from A to T, which have been provided made available on the website as well, which sets out a number of documents to do with transport and ecological management and so on. So I won't go through those. They all seem to make sense. And the site, but anything so obviously the site plan for Appendix A obviously shows the red line boundary for the 106 rather than the appeal site. Hence why Derryman's is shown, and the line along the southern boundary. The Tynings land is shown in the southeast, and then the sort of phase 3 and 4 development plus spine road is also shown within the red line for the 106. So I think that's all sorted, and we have all the information on ownership for that. So unless anyone has any concerns, take that as all present and correct. So that's everything, I think, in terms of the 106, unless anybody wanted to have any specific points on the content. My only final question was execution. I note there, I think there are 13 signatures or 13 signatories to this. So how is that going to be carried out and what are the timescales, Mr. Tucker?
Certainly from my client's perspective, you'll appreciate this is something that there has been much angst behind the scenes in terms of getting it right. There will need to be a couple of tweaks, I think, following this discussion. So I'm asked for 14 days. I'm told that we are confident that relevant parts have been teed up and that that's therefore achievable. If for some reason, sir, there is a problem at the end of that period, then Sir will obviously notify the case officer and give reasons as to why we would need more time. But nonetheless, Ms Forbes, etc., assured me that 14 days should be sufficient. That said, I obviously defer to the council because this is a bilateral, and the council will have their internal issues as well in terms of whether that there is particular days when documents of this nature are signed, sealed, and delivered. Though happily, this is being done by DocuSign, so the process should be rather swifter than the civic seal coming out every second Thursday with a big stamp. So hopefully it will be a 21st century signing process, not an 18th century one.
Thank you, Mr. Tucker. I noticed there is an electronic execution and completion clause at 2021.
Exactly.
Yeah. Mr. Hewitson.
So just to support what Mr. Tucker was saying, it has been agreed that the documents will be signed electronically via DocuSign, which does, just to confirm, does mean we don't need to wheel the Lord Mayor in with an old-fashioned wax seal. This will be a 21st century execution, and I think all parties are confident it can be done well within 14 days.
Thank you. I know there's reference to counterparts if necessary. I'm obviously particularly conscious of the number of beneficiaries signatories required as well. But obviously that's yeah, it's a lot to sort of do in the old-fashioned kind of wet document. Everyone signs the same thing, kind of thing. So if everyone's happy with 14 days, I'm content to set a 14-day deadline for execution. Obviously, let me know if there are any problems, but 14 days from today takes us to the 25th of February. So I will look out for it on or before that date.
Thank you very much indeed, sir.
Thank you. Anything else on the 106 from anyone?
So I've seen a WhatsApp message that Miss Jenkins is now on the call, but I can't see her on the list at the moment. So if she's on the call, then no doubt she'll make herself known. But if not, maybe we can return to ecology after you break in a few moments' time. So if that would be acceptable.
Yes, I mean, if she's not there, then now would be a good time to have a break anyway. So we can do that and come back to pick up any final points on ecology overlap with conditions.
Thank you, sir.
And then after that, thank you. So then after that, we'll hear the first of the closing submissions, obviously from the Rule 6 party, Mr. Neil. So I was going to suggest maybe we break until 12 o'clock. Is that reasonable amount of time to adjourn until, or 5 to 12? Mr. Neil, are you ready to go with your closings?
I'm raring to go with my closings, not my wish rings. I think I'll be about 45 minutes.
Okay.
So if that helps.
Shall we say, okay, well, we maybe come back at 5 to then, 5 to 12, 11:55. And if during this adjournment, Mr. Neil, if you're able to send an electronic copy of your closings to my case officer and to the other parties as well, please, that would be helpful.
Yes, sir, I'll do that now.
Okay, thank you. Mr. Hewitson.
So can I just clarify, sir, will Ms Forbes and I be needed after the break?
I think if you can just be present for the very start of it, in case there's anything on the ecology consultants points, and then if not, then obviously both you and Ms Forbes are free to go. And obviously, thank you both for your time this morning.
Thank you, sir.
Thank you. If there's nothing else, then we'll adjourn for 15 minutes or so and come back at 11:55. Thank you.
Thank you, sir.
Thank you, sir.
Hello everyone, it's 11:55 and the inquiry is resumed. Do we have, I think it's Ms Jenkins, isn't it? Or I got the name wrong. The ecologist for the appellant, she?
No, the name's correct, sir. And I know she was trying repeatedly during the break, but I think the plan is that we may have to revert to a bit of a Heath Robinson approach, and Mr. Frampton is going to hold his mobile phone up to his microphone to allow Miss Jenkins to speak.
Okay.
Sort of a third way.
We'll see how that works. I mean, I think the kind of questions I have were relating to any duplication between condition, I think it was, bear with me, sorry, too many things open. Condition 14.
Yes, sir. If I can explain my instructions, and then that may help us before we revert. So condition 13 deals with ecology during the construction phase.
Yeah.
Condition 14 deals with protected species during the operations phase. And condition 15 deals with BNG, irrespective of the protection of protected species in condition 14. So there, yes, of course, there's an overlap because it's all ecology, but they are dealing with different aspects of ecology.
Okay. And
sorry,
in terms of the overlap with the 106?
That, sir, I'm told is because some works are required in perpetuity, such as the works in respect to the skylarks, whereas the BNG relates to a 30-year time period in the line with the DEFRA guidance, and that's why they've been separated out, just to make the life of the lawyer more complicated. But that is my instructions with regard to why there is the apparent overlap, but it's not, because they're dealing with those two different aspects.
Okay. Thank you. Is it Ms Jenkins wants to add anything else if she's heard that, or?
Yes, I can confirm I heard that, and Paul, you're absolutely right.
Okay, thank you. That's good to know. I don't think then, I think that's probably everything. And Mr. Hewitson dealt with the point about the license and for the bat license from Natural England. The condition requires something different to the 106 in terms of the obtaining of license or notification of license being obtained. Is that right for you, Ms Jenkins?
As far as I understand it, that condition is covering the fact that we as consultants would need to let the council know that yes, the licence has been approved by Natural England. Whereas the licence in relation to the applicant will be held, it will cover and bind their land. So they're two different aspects of obtaining a bat licence.
Okay, I understand. Okay, so I think so. So there's two different parts to it. Does everyone understand that from Ms Jenkins? Anyone need that clarifying, or?
But so your understanding confirms what I was told during the break. So yes, sir.
Okay. Okay. Well, thank you, Ms Jenkins, for that as well. I think that was everything then on ecology matters and the overlap. So I think just before we move on to closing submissions, I think that behind the scenes, Mr Frampton, Mr Griggs-Trevelyan may be looking at the building height condition and possible rewording of the phasing plan condition 11. I think they were the two main conditions, and then obviously any note from the appellant on agreement pre-commencement conditions would be helpful this afternoon. And then I think in terms of the obligation, I think there was just that paragraph 16 in part 4C of Schedule 1. I think some clarification as to the agreement of any alternative route prior to planning application being submitted. So I think Ms Forbes, maybe Mr Hewitson or somebody else from the council may just want to have a conversation about wording there, and maybe update later on this afternoon via the barristers advocates.
Yes, sir.
Thank you. Anything from anyone else on the conditions or obligations? Thank you all for to those of you who've taken part in that session this morning. It's been very helpful. So we'll leave it there and maybe pick up any last bits and pieces at the end of the day as needed. Okay, thank you everyone. So we have I've received a copy of the Rule 6 parties closing submissions, keeping up to date with the document numbering. Document ID 40 is the council's comments on the resetting document. ID 41 is the email from Mr. Frampton on the building heights condition. So I believe that these closing submissions will probably be ID 42, unless I'm told otherwise. And obviously they can be added to the website as soon as possible. That would be great. Otherwise, I think if there's nothing else to add, Mr. Neil, I think it's probably over to you to deliver the Rule 6 parties closing submission.
Thank you, sir. These are the closing submissions by the Rule 6 party, Southstoke Parish Council and Coombe Hay Parish Council, whom together I'll refer to as the parish councils. These closing submissions do not rehearse all the concerns the parish councils have set out regarding this scheme, nor all the evidence relied on. They focus on the main issues actively pursued in evidence by the Rule 6 party in light of the evidence heard, and set out the reasons why, in light of the key points emerging from that evidence, the appeal should not be allowed. Those issues relate to the non-compliance of this scheme with the placemaking principles set out in Local Plan Policy B3A, and therefore the clear conflict with the development plan policy, which is common ground, is the most important policy for the purposes of this appeal, including but not limited to the lack of a comprehensive master plan and the failure to deliver a residential-led mixed-use development. They also relate to the clear failure of the appellant to submit an adequate transport assessment, contrary to both local plan and national policy. On the question of heritage and landscape harm, the parish councils endorse and rely on the evidence of Miss Bowlby and Miss Priscott, but since those matters will be covered by the local planning authority, they are not dealt with in detail in these submissions. To set the context for my submissions below on those particular issues, two overarching points are worth stressing. First, the parish councils did not decide lightly to raise a considerable amount of funds from parishioners and the general public to produce evidence that could and should have been pursued by the local planning authority had it not been placed in a compromised position due to the views expressed previously by officers, both in the termination of this appeal application and historically during the Phase 1 application. Unsurprisingly, an appeal against a decision that was contrary to officer recommendation, the appellant's approach, at least hitherto in evidence and in questions put to the various witnesses at this inquiry, in response to several of the parish council's concerns, has been to refer and seek to place considerable weight on the position of Baines, both in relation to the question of the adequacy of its highways modelling and in relation to points about the comprehensive master plan. It is, of course, a matter for you, sir, to decide what weight to place on the views of Baines highways and planning officers in respect of those issues. But whatever the position local planning authority has adopted historically is, of course, not determinative of those questions. The relevant officer who, for example, agreed that there was no need for a comprehensive master plan at Phase 1, and the relevant highways officer, the external consultant from ACOM, who decided that despite previous acknowledgement that the network was congested, that there was no need for network modelling, have not given evidence to this inquiry and not been subject to testing under cross-examination. That is relevant to the weight to be attached to those views, and the ultimate question, of course, is whether or not the positions they adopted were correct. Second, contrary to what was asserted for the first time in the appellant's opening submissions, the parish council have never submitted that this site is not suitable in principle for redevelopment since the adoption of the local plan and policy B3A. All the parish councils have wanted to ensure is that the adopted development plan is followed and the right scheme is brought forward in this location. This is not a good scheme. It is a poor scheme that seeks to do the minimum in terms of any provision for the community and the maximum in terms of residential provision. The characterisation of this scheme in the reasons for refusal with which the appellant took issue in opening, namely that it's a homogeneous dormitory development, is entirely apt. It is hardly surprising that a scheme such as this will entirely fail to deliver the first fundamental development plan requirement of being a residential-led mixed-use scheme has aroused so much local objection. So firstly, compliance with policy B3A and the placemaking principles. The first question under that broad heading is, will this scheme result in a residential mixed-use development of the allocation for around 300 dwellings? The answer to this question is that, of course, it does not. Placemaking principle 1 is clear. It states that there should be a residential-led mixed-use development to include 40% affordable housing of around 300 dwellings in the plan period. It's important to distinguish at the outset the question of interpretation of the policy and its application, because the appellant's position, for reasons that will be explained below in my submission, blurs the two. That distinction is well known and is not contentious. See, for example, Tesco stores in Dundee, which you'll be well familiar with, and that's referred to in the appellant's own evidence. So the interpretation of policy B3A. As a matter of interpretation, the wording is clear. What is required is not simply residential development of the allocated land, but residential-led mixed-use development. Emphasising those words is not an example, to use Mr. Tucker's oft-cited phrase, of forensic archaeology of a policy. It is a basic and fundamental question of understanding the meaning and purpose of the policy. The inclusion of the words mixed use was a deliberate policy choice by the council in formulating this policy and must have been included for a reason. Importantly, those words contrast with other residential allocations in the local plan where this wording was not used, a proposition with which Mr. Frampton appeared to agree. And I've just said out of my footnotes, the distinction between this allocation and other residential allocations was put by me to Mr. Frampton. He was not taken in re-examination to any other comparable examples where residential allocation with open space provision was similarly described as residential-led mixed-use development. The reason a mixed-use component is important is because it creates a sustainable community, for all the reasons explained by Mr. Reynolds and by Mr. Waters. The unattractiveness of the unlit pedestrian cycle link through an open field to the north makes it all the more important that a mixed use is delivered on this site. The NPPF at para 96 is clear that development should promote social interaction, for example, through mixed use development that allow for easy pedestrian and cycle connection within and between neighbourhoods. This proposal clearly does not achieve that. The appellant's primary position, as set out in the evidence of Mr. Frampton, is to emphasise the word the allocation, and the appellant asserts that it does not require each planning application for every part of the allocation to contain a mixture of uses, and that's set out in Mr. Frampton's proof of evidence, the reference to which I've given you. Now that, of course, is correct, but Mr. Frampton also asserted that the new homes, public open space and allotments in this particular scheme comprise mixed use. That proposition, which appears to be an alternative argument to his primary contention about the meaning of the policy, is plainly wrong and is premised on a clear misinterpretation of the first place-making principle. Plainly, the inclusion of those words means that what is required is a genuine mixed-use development across the allocation, albeit one that's residential-led. Mr. Frampton's frankly bizarre answer to a question from an objector, Mr. Hellard, as to where the community facilities are, was to point to open green space and to suggest this was a community facility. And that highlights the flawed interpretation he's taken to policy B3A's reference to mixed use. Put simply, elements of the proposal that are simply ancillary to the residential development, the allotments and the open space, are plainly not sufficient to meet this requirement. There is no challenge to either Mr. Waters or Mr. Reynolds' evidence that the allotments and open space required here would have been required here in any event as necessary infrastructure required as part of any residential scheme. Such uses would clearly be ancillary to residential development and not primary uses in their own right. Mr. Frampton also appeared to assert that the existence of Odd Down Football Club and Manor Farm meant that the result here would still result in a mixed-use development of the allocation, as would the existence of other facilities adjacent to the site. That is, with respect to fundamentally misconceived interpretation of policy, and again, frankly, bizarre. The interpretation of planning policy requires the application of common sense. The appellant's approach in this respect, essentially that the words mixed use are OTOs and add nothing, is contrary to common sense and plainly wrong. The very fact that such a strained interpretation is advanced only serves to question and undermine the approach the appellant has taken to the scheme, namely to avoid providing the necessary community and other facilities that a mixed-use scheme ought to have. The simple point is that the policy refers to mixed-use development, i.e. development that we brought forward, not built form that's already there. Had it been intended that the pre-existence of the football club and manor farm and other facilities in the area was sufficient, then there would be no need to include the words mixed use in PPS 1. This is particularly so given that the other placemaking principles refer to manor farm and football club in any event under PPS placement principles 9 and 10. So with the application of placemaking principle 1, would that result in a residential-led mixed-use development of the allocation? The very fact that the appellants thought it's necessary to advance these alternative and plainly flawed arguments as to what PPS 1 means merely betrays the lack of confidence it has in its real approach to the scheme all along, i.e. that this scheme does not need to provide any mixture of uses at all. That is a plainly flawed application of policy once properly interpreted, for the simple reason that A, the bulk and remaining balance of the allocated land identified in its own master plan as suitable for residential development will be developed by this scheme, and B, the appellant has not provided any evidence that a mix of uses will come forward in phase 2, nor is any such mix of uses identified in its own master plan. So now turning to that question, is there a comprehensive master plan for the purposes of PPS 2, placemaking principle 2? The approach of the appellant to the mixed use requirement merely serves to highlight the other principal flaw in the entire rationale behind the scheme, namely the lack of an agreed comprehensive master plan for the strategic site allocation. Put another way, had there been a comprehensive master plan setting out in advance the other mix of uses that might come forward in separate applications, then the appellant may, and it's put no higher than that by the Rule 6 party, have been able to demonstrate why, despite this particular application plainly not being mixed use, the policy requirements of PPS 1 would be met. But the requirements in PPS 2 are not met for at least 2 reasons. First, there's not been a public consultation and agreement by the council on a master plan in advance of any phases of this scheme, including this phase. And second, in any event, the master plan that's been submitted is not a comprehensive master plan for the purposes of the second placemaking principle. So what does PPS 2 require in terms of process? Again, this is a question of interpretation and essentially a matter of law. The requirement for public consultation and, I quote, agreement by the council, when read in context with the rest of the placemaking principles, is clearly an additional separate requirement over and above the normal process of notification and public consultation that occurs with any planning application, a proposition that Mr. Frampton accepted. It was no part of the appellant's case, at least as presented in this inquiry, that this requirement could only have been met through a planning application process. Mr. Waters was not challenged on his evidence that the way this requirement could have been met was through the consultation adoption of a master plan as supplementary planning guidance. It is no answer to this that the council did not promote a master plan and adopt it as SPG. It was for the appellant to ensure that their proposal complies with PPS 2. Instead, it was put to Mr. Frampton in evidence in chief that the best way to achieve this would be through a planning application. That is plainly wrong. It makes sense that there should have been such a process carried out in advance, not just of this application, but also phase 1, because it is the only way that the clear purpose of a master plan as defined in the local plan could be achieved. The local plan, when adopted in 2014, defined a master plan as, I quote, a document outlining the use of land, an overall approach to design and layout of the development scheme, in order to provide detailed guidance for subsequent planning applications. And I've given you the reference there, which I won't read out my submission, sir. Also relevant to understanding the meaning of the master plan is an extract set out in the placemaking plan at AG3, page 87, paragraph 186. That states site-specific design requirements are included within placemaking plan and core strategy site allocations. Master plans are typically required to be prepared for more complex sites or where sites are in multiple ownerships, and are always encouraged for complex or multi-phase developments. So turning to the flawed approach of the appellant to master planning, the appellant's position is that a master plan for the purposes of PPS2 could just be consulted and submitted alongside and part of the specific planning application is plainly wrong. It's clear that Mr. Frampton had not understood the purpose of the master plan as referred to in PPS2. He had not referred to the local plan definitions of master plan as evidence, and when taken to them suggested that A, the reference to planning applications in the core strategy meant a reserved matters application, and B, multiple ownership did not apply to a site with at least 3 different owners. Both assertions are self-evidently wrong. What was actually consulted on for this application is set out in the design and access statement. That stated in terms that the purpose of the consultation was to inform the design evolution of the scheme. Whether it did so or not is a separate question. Many objectors understandably take issue with that. But the point is that it was plainly not a public consultation on a separate master plan to guide subsequent planning applications, but merely a public engagement exercise on a self-serving plan to support and justify this particular application. As such, and this links back to what we've just heard in the condition session, it adds absolutely nothing to other application documents that constrains this particular scheme. For example, land use parameters plan. The appellant's position, at least as suggested in the response by Mr. Frampton about the role of a comprehensive master plan, appears to be that any historic failure to agree a master plan in advance of any planning application at phase 1 was the fault of the council, and is therefore not a reason for refusing this application, i.e. essentially a submission that each scheme should be determined on its own merits. The latter submission, i.e. each scheme should be determined on its own merits, is of course correct, but is no answer to the failure to comply with PPS2. First, what boils down essentially to a sins of the past should not be revisited on the present generation argument might hold some force were it not for the fact that it is an express policy requirement as set out in PPS2 that such a process should take place. Secondly, this clear failure in process does have real-world consequences. The absence of a jointly promoted master plan means that this inquiry still has no clarity about what will occur in the blanked out sections of the current 6th version of the master plan, R12, and therefore when, how, or if the rest of the allocation will in fact deliver the mix of uses required. What will come forward in phase 2? Mr. Frampton, in his written evidence, denied that 50 units will come forward to support his client's position on density, and said in his evidence in chief he did not know what would come forward. However, 50 units is precisely what the private commercial agreement, which this inquiry cannot scrutinise, appears to indicate as an aspiration of the current phase 2 owners of Sulis Manor. And finally, what this inquiry still has no clarity about is whether those parts of the site apparently relied on for its sustainability, meeting the mixed use requirement, will in fact be retained, i.e. e.g. the football club or manor farm. In circumstances where there is a need for master planning, expressly identify the council and its local plan. It's not good enough for an appellant to try to appoint, for an applicant, to try to point to a lack of objection of evidence of what the current landowners may or may not wish to do, or lack of objection, for instance, the intention of the football club, etc. It is not for objectors to seek to reduce that evidence. All this could and should have been determined as part of the master planning process. What has occurred is the antithesis of joined up planning and has resulted in precisely the type of piecemeal approach that Mr. Frampton agreed a master plan was designed to prevent. Furthermore, the lack of an agreed master plan means that there's a real risk of over provision of infrastructure and ancillary provision required to support the phase of development. The fact that there's an application for allotment provision and derriments outside the application by the current phase 1 owners running alongside this application is not only symptomatic of a failure to follow the correct master planning processes by the developers of this allocation, but it also results in the very inefficiency in the use of land which the appellants say, citing paragraph 130 of the NPPF, will be avoided by its increase in units from around 300. Many of the flaws in the master plan have been set out above when explaining the failure in process, and explains why two wrongs in the process to secure a master plan do not make a right. As to the adequacy of the comprehensive master plan in other respects, including the lack of overall guidance for the entirety of the allocation, and the lack of certainty over the certain total number of houses, this is explained in the evidence of Mr. Waters. He is not alone in that view. It was in fact one shared by the council at phase 1. I'll give you the reference for that, sir, including its own landscape officer, and indeed by the council's planning officer, at least initially, when considering the appeal scheme in March 2021. One only has to compare the original master plan set out in phase 1 and the current one at phase 3 and 4, submitted part of this application, to see that those issues were not addressed. So now turning to the adequacy of the appellant's transport assessment, the issues between the respective parties' experts is the technical, but nevertheless critical issue of disagreement between the transport witnesses regarding the accuracy and appropriateness of the baseline junction modelling, which underpins the appellant's TA and 2 addenda, and therefore whether or not traffic impacts are being correctly predicted. This relates in particular to the assessment of baseline conditions around the key junctions of Odd Down Roundabout and the Red Lion Junction. So looking at the relevant provisions of the NPF and local planning policy in relation to transport assessments, before turning to the deficiencies in the TA, it's important to understand how the adequacy of the TA is relevant to the question of compliance with national and local policy and the relevance of the evidence that the parish councils, in particular the survey work carried out by Alan Bales, in that regard. Mr. Pinto in cross-examination fairly and reasonably accepted that if the appellant's TA was not adequately modelled, has not adequately modelled the baseline traffic conditions in the highway network around the scheme, then the inspector would not be able to assess the likely highways impact of the scheme. And secondly, if the inspector cannot assess the likely impacts, the proposal would be contrary to paragraphs 118 and 115D of the NPPF. And finally, if the inspector does not have sufficient information to understand whether there would be an unacceptable impact, then that would be a material consideration. The fact that the NPPF states at para 116 that the development should only be prevented or refused on highway grounds there would be an unacceptable impact on highway safety, or the residual cumulative impacts on the road network of the road network following mitigation would be severe, taking into account all reasonable future scenarios, plainly does not preclude the refusal of permission on the grounds of non-compliance with other parts of the NPPF, including 115D and 118. Merely indicates the level and type of impact that should lead to a refusal if there has been a proper assessment actually carried out. It would make a nonsense of the NPPF, in particular render those other provisions relating to the need for TAs entirely pointless to read it otherwise. The same approach applies to the relevant provisions of local plan relating to the assessment of highways impacts, as set out in Mr. Russell's proof of evidence on page 29, i.e. policies ST1 and ST7. So just turning to the purpose of the Alan Bales drain surveys, the parish councils, as acknowledged and reflected in the evidence of Mr. Russell, have never sought to carry out their own transport assessment of the traffic effects of the scheme, or suggest that the evidence that they produce constitutes such an assessment. It's not for a third party, or for a local planning authority for that matter, to produce positive evidence showing the lack of highways impact. The whole thrust of the, sorry, that shouldn't actually say the lack of highways impact, it should just say showing a highways impact. Sorry, so if you don't mind deleting the lack of.
Yes, okay.
On that sentence, that clearly isn't the right, there's clearly a typo there. The whole thrust of the provisions of the NPPF is to emphasise the need for applicants to demonstrate via transport assessments what the likely impacts would be, so that the planning decision maker, i.e. you, sir, can take a view on an informed basis. The purpose of the drain survey work carried out for the parish councils by Alan Bales Consultancy Limited was to point out, using the Odd Down Park and Ride Junction, the Red Line roundabout, as particularly egregious examples of how flawed the TA is, and in particular, the lack of calibration of the model to reflect the actual degree of congestion and demand flows for those junctions. That work would not have been necessary had the local authority not changed its position previously adopted at phase 1 that the junctions were congested. In his proof of evidence rebuttal, Mr. Pinto reviewed the still photographs of queues on the A36 in the Alan Bales report. He deduced, based on no quantitative evaluation, that figures 2.2, 6 images of the A367 between 803 and 0853 does not suggest queuing, but rather slow-moving traffic in the AM peak. Mr. Pinto made in his rebuttal no reference to table 2.3 of the Alan Bales report that shows the delay times on the A36 between 7:33 and 9:02, nor did he attempt to reproduce these measurements through evaluation of still images and drone footage, all of which are freely available. Mr. Tucker, in his cross-examination of Mr. Russell's, referenced a TRL doc report, which said that 5 kilometres an hour was assumed for all queues, and said that this was a useful yardstick. Mr. Russell agreed with that. Mr. Tucker also put forward an estimate of 600 metres as the queue length in the still photographs. Mr. Russell agreed. The arithmetic put to Mr. Russell in cross-examination badly backfired and merely demonstrated that the application of TRL's 5 kilometre an hour assumption, when applied to Mr. Bales' analysis, actually demonstrated queuing. Using the TRL yardstick, a queuing time of 9 minutes along a distance of 600 metres would be at a speed of 4 kilometres an hour. Every delay measured between 7:52 and 8:53 in table 2.3 of the Alan Bales report is greater than 9 minutes, and therefore be moving at a speed of less than 4 kilometres an hour. This therefore constitutes a queue by the very criteria we learnt for the first time in examination chief was apparently used by Mr. Pinto. What is telling is that Mr. Pinto deduced that the images presented in the Alan Bales report did not constitute queuing, but just like his own CCTV review, this was clearly based, should remove the 2 thises at that point, on a subjective assessment of the drone footage and not on the available measurement of the delays. He came to exactly the same view in the TA without any actual measurements to validate his assumptions and assumed there was no queuing. But in any event, whatever criticisms of the work of Mr. Bales the appellant may try and advance, for example, did he take averages or maximums in table 2.1 and 2.2, this entirely misses the point. All the Bales drain survey work and the data extrapolated from it was to demonstrate what is blindingly obvious to anyone visiting these junctions at the AM and PM peak and who is remotely familiar with the road network in this location, namely that they are already seriously congested and therefore the model should have been calibrated. And this was the point in Mr. Alan Bales' technical note on page 52. The outcome of the Bales drain survey, namely that there's already congestion, is entirely consistent with the views of the local authority when phase 1 was assessed in 2017, and in particular its observation that the area was sorry, I've misquoted his observation that several, I think that should be the junctions, are frequently congested in the peak hours. The views expressed by the Council's planning officer, Mr. Triggs of Arthman, 7th March 22, in relation to the proposals. He said, given the highway is already at capacity along this section, it's likely that any significant development is only going to add this problem, resulting in significantly more congestion, and I stress the word more congestion. It's also inconsistent with the initial reaction of the Highways Authority to this application, September 22, and it's also inconsistent with what several third parties at this inquiry stated to the inquiry was their experience of these junctions. It's also inconsistent with the evidence of Mr. Russell and what he observed at these junctions. You, sir, would have seen for yourself the level of congestion when visiting these junctions during the AM peak, during the inquiry. All of this constitutes clear evidence that the model needed to be calibrated and factor in congestion to reflect the actual circumstances on the ground. Now, just turning to in a bit more detail to the inadequacy of the modelling carried out by the appellant, the Parish Council's position remains that the modelling carried out by the appellant's transport consultant is clearly inadequate, primarily because of the lack of any quantified, objective, observed data on queue lengths to demonstrate that the modelling of the baseline conditions, which assumes no congestions at these junctions, is realistic. Related to that is the question of whether or not network or standalone junction modelling is appropriate. In a congested area where there is a risk of interaction between junctions, it is clear that network modelling is the appropriate type of model to be used. The use of network or standalone models, Mr. Russell's evidence reference sources of good practice, including the TfL transport modelling guidelines, which clearly indicated in a heavily congested area, a network model is more appropriate. It is true that Mr. Russell accepted in cross-examination that in principle a standalone junction model could be used, but that was clearly subject to the important qualification to whether or not it was properly calibrated. Mr. Pinte's evidence as to why a network model was not used, in my submission, did not stand up to scrutiny. The various and differing reasons advanced to him as to why no network model is necessary. First, advanced by him as to why no network modelling was necessary, first asserted in Appendix 2 of the TA, and then repeated in various different documents thereafter, including his voluminous proof and rebuttal, were not convincing. The very fact that these reasons have, putting it neutrally, evolved between the application process and Mr. Pinto's proof in itself is telling. The latest summary of reasons why Mr. Pinto thought network modelling was necessary was set out in his rebuttal, paragraph 3.7 to 311. Taking them in turn, they're either wrong or unconvincing as reasons for not using a network model. Firstly, the small network of junctions. This was not the reason originally put forward in the TA addendum, and that's because it's inaccurate. There are several junctions here, all of which were identified in the TA as requiring assessment, evenly spaced out. This was asserted in the TA addendum at para 2.48. Mr. Pinto accepted in cross-examination that this was in fact not the case, and that there were at least 2 clusters of junctions. The fact that the junctions are priority controlled, why the lack of non-signalised traffic movement shouldn't make any difference to why a network model should be used remains thoroughly unclear. An alleged lack of interactions with public transport. This is an area of the bus lane, for example, approaching Red Line roundabout from the north. There are bus stops on all the major routes. The heavy and repeated reliance he and the appellant place on the change position on Baines Highway is misplaced. Baines' concerns over the lack of a network model were set out, giving you the reference there, sir, and centred on the lack of analysis as to how the junctions interact, the impact of additional queuing between junctions, and identify the already congested network. It stated, or Baines Highway stated, the effect of the development needs to be assessed and quantified using the model to properly understand the impact of this development and how the junctions interact. The VISIM model has not been used to assess the impacts on the wider network and will show the impact of additional queuing between junctions. There is no justification in the submission for its exclusion or why standalone capacity models have been chosen. In response to that, the reasons advanced by the appellant, which were then accepted by the local highways authority, were reasons why the VISIM model were not appropriate, not why a network model was inappropriate. And you can see that in the Baines Highway response, which I've given you reference to there, sir, CDAA 71, and the references to age, unrepresentative traffic flows, and unrealistic trip rates. Those are two separate questions. Notwithstanding the weight that is to be attached to a local highways authority's views, it is entirely open to this inquiry to evaluate the reasons why Baines Highways changed its position and decide if they're convincing, particularly as the local highway authority has not given evidence for this inquiry. It is plain and highly regrettable that Baines Highway failed to distinguish between the appropriateness of a VISIM model and the separate question of whether or not a network model of whatever type was required. Now, just turning finally to the question of calibration, before examining whether or not a calibration exercise was carried out, it's important to note why calibration of a standalone model is necessary. There was no challenge to Mr. Russell's explanation that a standalone type of the model used by the appellant does not include demand flow unless calibrated to do so. Mr. Pinto accepted that no such demand flow, i.e. in layman's terms queuing, is automatically included, and that the standalone model of the sort used by Tetra Tech here is based on throughput. So that is why calibration is so critical for a standalone model, because without it, no account is taken of how many vehicles may be waiting to cross a junction. Now, when determining if the model has been appropriately calibrated, the starting point for this inquiry is to have regard to sources of good practice. Mr. Russell correctly identified sources of good practice, namely the web tag guidance and the software designer's own guidance as to how the model should be calibrated. Mr. Pinto, in his written evidence, criticised Mr. Russell's citation of the web tag guidance on calibration and considered he'd taken it out of context. But in cross-examination, he accepted, in fact, that he took no issue with what was said in the web tag guidance, namely that a highway model should check that a response is realistic based on empirical evidence. Mr. Russell was quite correct to refer to that guidance, and Mr. Pinto's criticism as reference to it was entirely misplaced. Equally valid was Mr. Russell's reliance on what the software designer of the model used by the appellant, i.e. TRL, who designed the Junction 9 model, itself recommended in terms of calibration, i.e. the comparison of the use of modelled versus observed queue length data. Mr. Pinto's latest position as rebuttal was not that there was no need to carry out such an exercise, but rather that he in fact carried it out. It's evidence that he'd not in fact used any observed queue length data because none had been extrapolated from the CCTV footage. And indeed, it's hard to see how it could have been unless CCTV cameras are also recording the queues themselves and not the junctions, but there's no evidence of what they actually recorded. His evidence on this issue is inconsistent and his answers on this critical issue evasive, in my submission. He asserted expressly in his rebuttal at paragraph 2.14, queue data was indeed used, with Tetra Tech and Baines reviewing CCTV footage. However, this is inconsistent with his main proof at 337. Modelling outputs were not reviewed against queue survey data. He stated in cross-examination that data would have been extrapolated from the CCTV footage, but when pressed on where this data was and why it not being provided to Mr. Russell, despite a repeated request for it, accepted that in fact no such extrapolation had been carried out. He finally conceded that his review of the CCTV footage in fact simply boiled down to him reaching, and I quote, a subjective view of what the CCTV footage showed. These inconsistencies and evasiveness fundamentally undermine the weight to be attached to that subjective view of Mr. Pinto, i.e. that any queues were simply the function of the design of the junction and vehicles slowing down to cross it and not congestion. The clear lack of any extrapolation of data by the appellant from the CCTV means that precisely sort of the questions the appellant thought it appropriate to raise with the Bale survey work, and in particular tables 2.1 to 2.2, simply could not be put to Mr. Pinto and tested at this inquiry. Even if Mr. Pinto, when watching the CCTV footage, was not in fact labouring under the same error in his written evidence as to how he defined a queue, i.e. the fairly fundamental error at para 371 of his main proof as to what is a queue, clarified in examination in chief. There is no way of knowing how, for example, he applied the average queue length speed suggested in TRL guidance, which Mr. Pinto adduced in evidence in chief at the last moment, and how he did so, including camera positioning, etc. For precisely the same reasons, there's no way of knowing how the local highways officer reached the same view as Mr. Pinto. This was not, as suggested by the appellant in opening, a review of ACOM by 14 days worth of data, as applying as it did some sort of external review validated by an external organisation. As Mr. Russell explained, he'd seen no such review. It transpires, in fact, it was merely the subjective opinion of a consultant employed by the local highways authority to deal with this application. In short, the failure to extrapolate that data and submit it alongside the TA was directly contrary to the recommendations of the designer of the appellant's own model and directly contrary to best practice. What this has resulted in is a TA that contains no actual measurement of actual delays, nor any factoring in of any such delays into its model. In short, that renders the TA fundamentally inadequate. Significantly, it means that this inquiry cannot be satisfied that the model's assumptions as to baseline conditions are realistic, i.e. that there's no congestion at all. And this is particularly so given the obvious and glaring discrepancy between what a plethora of third parties have observed at the junction stated to this inquiry and what the model has assumed. In all the circumstances, it's clear that TA, based as it is on that subjective view of Mr. Pinto, and without any observed queue length data, is not an adequate TA for purposes of national and local policy. So just briefly, turning to other issues, landscape and heritage harm. As to the effect of the proposed development on landscape and the Cotswold AOB, and the effect on the significance and setting of the World Heritage Site and the setting of the South Stoke Conservation Area, the parish councils are in broad alignment with Baines and endorse and rely equally on the evidence of Miss Priscott. Should say, and also Miss Doody. There will no doubt be addressed these will no doubt be addressed in council submissions, so not repeated here. In terms of the exceptional circumstances test, again, the parish councils are aligned with Baines' position on this and rely on what was set out by Mr. Reynolds and Mr. Waters. The concession by Mr. Frampton, examination chief, the exceptional circumstances test does apply, is a fundamentally important concession that could and should have been made earlier. Suffice to say, Mr. Frampton's evidence placed far too much weight on the 24 inspectors' conclusion, now 10 years old, which was clearly and self-evidently based on a figure of around 300 dwellings. Mr. Waters explained material circumstances have changed since that finding, as set out in his proof, para 627. In terms of the heritage balance, Mr. Waters explained why, notwithstanding the council's change in his position, in his view, the public benefits do not outweigh the less than substantial harm to heritage assets identified by the council. The key point he's made is that the need for market housing over and above what the council is required to provide to meet its housing requirements in circumstances in which the council is currently able to demonstrate 5 years' worth of housing supply does not outweigh the evident heritage harm of the proposal for the purposes of para 215 of the NPPF. So finally, planning balance. It does not appear to be disputed by Mr. Frampton that full weight should be applied to policy B3A, nor can it be seriously disputed, given its common ground that it's the most important policy relevant to the determination of this appeal, that if there is a lack of compliance with the relevant placemaking principles set out in B3A, that this would justify finding of lack of compliance with policy with the development plan as a whole. The parish councils fully agree with Baines in its identification of the multiple breaches of policy B3A and its placemaking principles. PPS 1 is not met because the proposal fails to deliver a mixed-use development, clearly envisaged in PP1. The policy clearly envisaged a residential mixed-use scheme. PPS 2 is not met because a comprehensive master plan has not been prepared, the strategic site allocation through public consultation, and has not been agreed by the council to guide future phase planning applications. PPS 3 is not met due to inadequate provision of green infrastructure for the reasons set out in the parish council's written submissions. PPS 5 is not met because the development will fail to avoid or minimise detrimental impacts on the AONB, the character of the Cambric Valley and Sulis Manor Plateau, and the setting of South Lake Conservation Area. Parish councils fully endorse the reasons set out in Reason Refusal 1 and the conflicts identified by the council with the additional local and national policies set out in that reason for refusal, i.e. policy NE1 and the NPPF paragraphs 189 to 190. The conflicts with heritage policies set out in Reason Refusal 2, i.e. B4, HE1, and the NPPF paras 202 and 114. The conflicts with policies D1, D3, and ST7, and paragraphs 98 and 139. In terms of the benefits the scheme would bring, the parish councils are also fully aligned with Baines and agree that substantial weight should be attached to the provision of housing, including affordable housing, as agreed in the Statements of Common Ground. However, in summary, for the purpose of the overall planning balance, the parish councils maintain the undoubted benefits of the scheme in terms of delivery of housing do not outweigh the clear and numerous conflicts with the development plan outlined above, and the harm the proposal will bring in terms of landscape harm, harm to heritage, harm for the failure to create a sustainable community, and the harm arising from the failure to accord with placemaking principles set out in B3A. For those reasons, sir, and those set out in its written representations, the parish councils will respectfully invite you, sir, to dismiss this appeal. Those are my submissions, sir. Apologies, I overran my 40-minute guesstimate.
That's okay. Thank you, Mr. Neal. That obviously brings the Rule 6 parties closings to an end. So thank you for delivering those. We'll turn to the council's closing submissions next. I'm just conscious of the time, and Mr. Morgan, how long do you think you'll need to deliver council's closings?
I said up to an hour, so and I think I will be around about there, possibly a touch less, but about 55 minutes.
I was just wondering whether we wanted to take a break, not a full lunch break, but maybe a break before those are delivered. And then obviously I'm happy to take another break after you deliver those before the appellant's submissions. So are you comfortable with a sort of 20-minute break or so, Mr. Morgan?
I'm very comfortable. Just a short comfort break's fine by me, sir. Thank you. I've sent my closings to Mr. Salter, sir, and to my friends. Just sent a few minutes ago, so hopefully they'll be received safely.
Thank you. Yes. So if we take a 20-minute break or so, then and we'll resume at 1:10 if everybody's happy with that. Thank you for the break. Okay. Well, thank you all. We'll adjourn then until 1:10. Thank you.
Thank you, sir.
Hello, everyone. It's 1:10 and the inquiry is resumed. Are we happy to make a start with closing submissions for the council? Anything before we do that? Okay, Mr. Morgan, I have obviously a copy of your closings. Thank you for that.
Thank you, sir. Thank you. And the other parties, them, I believe, and I'm grateful for them, the acknowledgement I had from the appellant. So can I, just before I start, just a couple of very brief preliminary points. I apologise now for the typos that remain. However hard you look at these things, typos remain in these documents, and I apologise now. I hope there aren't too many. Okay. And the other thing I was just mentioned, so I've referenced the sources of most of my submissions in footnotes in the conventional way. I won't refer to or trouble you with the footnotes, save on one or two matters where it might be relevant. So I hope that's an acceptable approach.
Yes, thank you, Mr. Morgan. I think this will be inquiry document 43 in terms of your closing submissions. I think that's where we're up to on the list. But if there's nothing else, then please begin when you're ready.
So, thank you. By way of overview, sir, as often happens, the cases of the appellant and the LPA have crystallised somewhat. Despite much discussion about the application of policy B3A, the differences are, I hope, clear. The differences are important and reflect competing planning interests, both of which have merit, but where the balance lies, we say, is clear. So the appellant has failed to give full cognizance to the importance of national landscapes and the impacts that the appeal proposals would inevitably have on the Cotswolds national landscape. This was abundantly clear, we say, from Mr. Frampton's evidence, as I will address below. His evidence was underpinned by a focus on housing need, which, although of course highly important, does not necessarily override the great weight given to conserving and enhancing landscape and scenic beauty in national landscapes, which are attributed the highest status of protection in respect of those issues. Further, the appellant has taken an unjustly liberal approach to B3A. It was agreed by Mr. Frampton that the allocation under that policy is for around 300 dwellings for the planned period. It is also agreed that this figure is not a cap, provided that all relevant placemaking principles are met. However, given the legal and policy importance ascribed to national landscapes, one of the key requirements necessitates that the allocated development avoids or minimises detrimental impacts on the Cotswolds national landscape and related aspects. As the evidence has clearly shown, this requirement would not be met by the proposals. Additionally, one of the basic requirements arising from PP1 is that the development of the allocated site should be a residential-led mixed-use development. Neither the Phase 1 development, the master plan, nor the current appeal proposals, in the council's view, meet that requirement. The tilted balance under the framework, paragraph 11 of that, does not apply and is not and cannot be in any event relied upon by the appellant in light of the authority's housing land